Good morning.
Morning. Okay, with the
Yes, please.
Lordship, with the consent of the other side, Lordship, let me mention item number 54 of the supplementary list today. There is some personal difficulty of Council D. Saraf. So
54.
item 54 supply list today.
As prayed for by Mr.
SS Gupta.
S.S. Gupta, learned counsel for the petitioner with consent from the other side, relist after 2 weeks on a date to be fixed by the registry.
Public.
Wait, Mr. Lordship. Lordship, we're appearing for the petitioner, item number 31 of today's daily list. We have filed the additional affidavit in the matter. I pray that the same may be called for.
Call for.
Call for.
Yes. All right, Mr. Das. Yes.
Two,
Item number
22. Requesting to adjourn the matter for 2 weeks or possibly take up the matter after puja vacation.
you are for the petitioner.
No, Lordship.
Have you taken consent from the petitioner?
Yes.
As prayed for by Mr.
RC Alam.
So and so, learned counsel appearing for the respondent with consent from the other side, relist after 2 weeks on a date to be fixed by the registry. Yes. Next.
With your Lordship, I beg to mention item number 40 for adjournments.
What is which one?
1-4, Lordship.
1-4.
Yes.
14.
Oh, yes. Okay.
You are for?
Petitioner, Lordship.
You are for the petitioner.
Yes, Lord.
Have you informed the other side?
Yes, my Lord, I am in this.
Any objection?
No.
As prayed for by Mr.
Lordship and Ali.
N. Ali.
Yes.
Learned counsel appearing for the writ petitioner, relist after 3 weeks on a date to be fixed by the registry.
My name will be.
That's only an adjournment. You want your name, give it. Naam to delay. Did you?
Lordship, in this item number 62, the personal opinions there, Lordship, we are filing affidavit today, so that will be recommended also.
And Mr. Chesty, if the officers are here,
Yes,
no, whenever they are here,
Yes.
I don't want them to be
Yes.
waiting. So you indicated to the
Yes,
courtmaster, provided the affidavit has also
yes,
come,
yes.
and then we can call it up. Please also inform the other sides as
Yes.
well. All right?
Yes.
You
Okay.
please look into that.
Yes.
Yes.
For withdrawal, item number 51.
Naam gita available. Miss, your name? Heard MS so and so, learned counsel appearing for the petitioner. Anyone? Come in. No government counsel in this court today? Item number 1. Is it? I think it's GA Assam.
I think item number 51.
Hmm?
This is item number 51.
Correct. 51, it's withdrawal. GA Assam. You're there, or I should record CGSE's name? Huh?
This is one only.
No,
Lordship.
the
I
withdrawal.
apologize.
Also heard MSM Bhattacharjee, learned additional senior government counsel for the state respondent. MS so-and-so, learned counsel for the petitioner, submits that she has received instructions from the petitioner not to press the instant writ petition and accordingly makes an endorsement before this court. In view of the aforesaid endorsement, the writ petition stands dismissed on being withdrawn.
For admission, item number 1.
Ma'am. This matter is,
Appointment to the post of constable.
yes, my lord. Initially, they are appointed, offer of appointment was given. Thereafter, my lord, the offer of appointment was cancelled without showing any reason. Kindly go through my case 23 of the petition. It's honorable court order,
Page.
case 23.
Pleadings are complete. Yes. 17-216 order.
Yes, yes.
What do you, which part of the order you want this court to look into? Please read.
In this order, my lord, this court already directed to appoint the petitioners. But my lord, the department concerns was please go through my lord, para 11.
Yes, I am in para 11. Please read.
As already noticed above, none of the petitioners belong to OBC category. 4 of them belong to scheduled tribe, 1 of scheduled caste, and 1 to unreserved. Is general category. In the affidavit filed by the respondent, it is stated that the discrepancy found in the merit list pertaining to OBC candidate respondent on 5 to 11 are all OBC category candidates. Selection was carried out category-wise, such as unreserved SC, ST, OBC, and ex-servicemen. If selection was carried out separately under different heads, question of petitioners competing with respondent on 5 to 11.
All right, para 13 is the operating
Yes,
portion.
my lord, yes.
May therefore look into the above aspect of the matter having regard to the selection record.
Yes,
If the
yes.
selection of respondent numbers 5 to 11 are not at the cost of the petitioners, selection and after of appointment, offer of appointment of the petitioner should not be interfered with, while at the same time not interfering with the selection respondent numbers 5 to 11. Let so and so look into the all aspects of the matter and pass appropriate orders.
My lord.
Yes, where are these orders?
That is my lord.
The orders are not passed till now.
It's passed now.
Where?
Next, my lord, page 28.
Page?
Page 28.
Page?
Page 28.
Yes.
Next page.
You are challenging this order.
Yes. In this order, my lord,
So some examination has been done and they have passed an order. What is wrong? In view of the fact enumerated above, the petitioners are otherwise not entitled of the advantage of their selection, which was found to be erroneous at the cost of deserving candidates. The recruitment process was completed with due fairness and transparency and in accordance with the policies of or instructions issued by the Government of India time to time. Nothing is illegal or irregular has been done in the selection process. Therefore, petitioners could not be selected for the post they have applied. Now, what is wrong in this? A detailed order has been, after examination, has been passed.
oh, my lord, kindly come to the page 31.
Yes.
That is in the first, my lord, first line, it's the petitioners. All
Yes.
petitioners obtaining the mark, which is all passing mark, my lord.
So,
As per advertisement.
passing itself will not be enough. There is a detail, everything has been considered.
Well,
That's sufficient. That is not sufficient. What else is there? What is the ground of attack? You want to take it on another day?
my lord.
Huh?
But, I will find another case law and.
Yes, you see, this is the old matter, so I don't want to put it in the hearing. I'm keeping it in the admission list, but come fully prepared because if you are now challenging the order, which is passed in compliance, appears to have been passed in compliance of the High Court's order. Now, the sufficiency of that, this code in 226 cannot go into. the authorities were asked to verify, re-verify. The authorities have re-verified and found you're not entitled. Now, if you have to make out a case that that verification is wrong, then you have to come with something very solid proof, huh? Heard Mr. N. Borman, Learned Counsel appearing for the petitioner, also heard MS R. Devi, Learned CGC. Relist on such and such date to enable the petitioner to place authorities in support of the relief sought in the writ petition. And date দিব
Deeply obliged.
Item number 2.
No, this matter relates to whether petitioner is entitled for NPS or OPS. A similar matter, Lordship has fixed that writ petition WPC number 2236.
All right, as prayed for relist along with so and so.
WPC 2237 of 2019 in the month of October.
2237.
Give the number to Ms. Bhattacharjee. Yes, yes, next.
Item number 3.
Lordship, here in this matter, the affidavit has gone for vetting, Lordship. Lordship, can this matter be taken up on Friday, Lordship?
Friday. Yes. The respondent is also being very fair. He is not saying adjourn it.
This is 13th
I heard Mr. CKS Barwa, Learned Counsel appearing for the petitioner, also heard Mr. D. Upamanyu, Learned
Standing Counsel, Higher Education.
Standing Counsel, Higher Education. Mr. So-and-so submits that the affidavit in opposition is ready and has been sent for vetting and assures that the same shall be filed on or before Friday. And stop. In view of relist Friday date to date on Saturday.
Item number 4 to 8.
Provincialization. Who is appearing in 4 and 5? Yes, Ms. Musari, affidavit.
Lordship, in item number 5 and 6, we have filed our affidavit. However, in other items, we have not. Lordship will grant us some time to file the affidavit.
Which one have you filed?
In item number 5 and 6.
In Mr. Datta's you have filed
Yes.
and
Yes.
Mr. Laskar in
Yes.
one of yours.
Yes.
So now you have to file in where?
Item
4,
number 4, 7 and 8.
4, 7 and 8. Okay. একেলগে লোৱা। Heard Mr. M. Datta আৰু সবৰে নামখিনি লৈ ল'ব। Please give your names against the writ petitions that you are appearing. Comma di pele, so and so, in so and so, so and so. Also heard MSD Mushahari, Learned Standing Counsel,
Secondary education.
Secondary Education. So and so submits that though affidavits in opposition has been filed in WPC 9497 of 2019 and WPC 2116 of 2022. However, she seeks for further accommodation in order to file the affidavit in opposition in the remaining writ petitions. Prayer is allowed. Relist after
Immediately after vacation, because there's some urgency in this matter.
after 3 weeks on a date to be fixed by the registry.
Item number 9.
Lordship.
Yes.
In this matter, Lordship, the petitioner was appointed as a junior engineer, Lordship, civil under the
Pay an allowance,
Lordship.
the correct scale. What is the correct scale according to you?
Subsequently, he was promoted, Lordship, but the pay scale of the promoted post was not given to him, Lordship. I am praying for that promoted pay scale with effect from 1/1/2013.
Pay scale of the promoted post.
Yes, Lordship, that of assistant engineer,
1 second. Promoted post. I assistant
engineer,
engineer with effect from
1/1/2013.
1/1.
2013.
Now, what is the reason given in the return for
Lordship,
not giving you the pay scale?
Lordship, they say that they do not have a stuffing pattern. They do not have a stuffing pattern. Until that stuffing pattern is being made, I won't be paid that.
What is the stuffing pattern?
Lordship, the municipal board employees actually there under the control of the municipal boards, and they are the autonomous, they get some grants in aid from the government and they generate their own fund and pays the salaries to the employees. Lordship, as there is no staffing pattern of the employees working in different municipal boards, Lordship, that's why it is regulated by the decisions or the resolutions taken by the board itself, Lordship. So this is done accordingly. Lordship, prior to the present board, the earlier board took a decision to upgrade the petitioner from junior to assistant engineer, Lordship. Subsequently, this has not been given effect to Lordship, and this was also by another resolution. And that apart, Lordship, the financial powers that is to be exercised by the chairman of the board, Lordship, this is also not done. I have annexed one.
Which is in your counter affidavit,
Yes, Lord,
where do I
it is-
find all this?
Yes, in the counter affidavit, Lordship, I have stated in page 39, paragraph 5, all these things, Lordship. Lordship,
They are saying that you are still working as junior engineer.
yes, Lordship.
Then where is the question of giving you the pay scale of assistant engineer?
And regarding.
There was yes, you are right. There has been a board resolution, but that resolution has to be brought into light. They are saying that resolution was never brought to light.
Lordship will kindly peruse page 26.
One sec. Let us, Miss, can one of you place paragraph 5? One of
Lordship,
you?
I'm reading for a Lordship. That with regard to the statements made in paragraphs 5 to 10 of the writ petition, the deponent begs to state that a board resolution was passed in the year 2013, upgrading the service of the writ petitioner from junior engineer to assistant engineer, and accordingly one order was also passed to that effect by the then chairman of the Borpeta Road Municipal Board. In that context, the deponent begs to state that the said order of upgradation of the writ petitioner has not been executed, and the writ petitioner is still working as junior engineer in the office of the Borpeta Road Municipal Board. It is pertinent to mention here in that at that point of time, the additional deputy commissioner of Borpeta was authorized to handle the financial power of Borpeta Road Municipal Board because of the then chairman of the board was barred from exercising his financial power by an order of the deputy commissioner dated 21/5/2013. And subsequently, there was handing and taking over of the charge on 29/5/2013. The ADC, who at that time was in charge of financial power of the Borpeta Road Municipal Board, had passed an order not to pay the upgradation salary till finalization of staffing pattern.
Yes. And which is that you wanted to show some?
Page 43.
Yes.
An exam. In compliance to the order number so and so dated 16/5/2013 issued on behalf of the government of Assam by the Commissioner Lower Assam Division Guwahati with curtailment of financial power of so and so Chairman Borpeta Road Municipal Board under this undersigned do hereby entrust so and so ACS Additional Deputy Commissioner Borpeta with the financial powers of the Borpeta Road Municipal Board to deal with all related transactions with immediate effect until further order. The officer authorized will take over financial charge and related files of transactions from the
So
chairman.
it has been
Borpeta Road-
authorized whom?
The ADC was supposed to handle all the financial powers, Lordship. And subsequently, there was another communication, Lordship, on the next page
Hmm.
with reference to the subject. Next page, page 44, Lordship.
Yes, I have it.
With reference to
Will
subject
take
cited
over.
above, I am to inform you that the undersigned will take over financial charge on so and so. You are therefore requested to make all arrangements accordingly.
So now the final charge will be taken over by the chairman.
Now it is not by the chairman, subsequently, Lordship.
It will be now taken by the additional deputy commissioner.
Yes, Lordship. Nowadays, Lordship, there is an amendment in 2015, Lordship. The ADCs are become the executive officer. So chairman is not the sole authority, Lordship, nowadays.
So it is the additional. Yes,
Lordship, Lordship will kindly turn to page 40 once again, Lordship.
40.
Yes, Lordship.
Yes.
Paragraph 5, the last portion, Lordship, the last line actually. The ADC who at that point of time was in charge of financial power of the Barberton Road Municipal Board had passed an order not to pay the upgradation salary till finalization of the staffing pattern. That is the last line, Lordship, but there is no order annexed to this affidavit, Lordship. And I have been told that there is no such order, Lordship.
No, but has there been an upgradation?
Yes,
Where
Lordship.
is the order
I-
by which you have been made an assistant
Lordship, will you kindly turn
assistant
to
engineer?
Page 23, once Lordship will kindly turn. Resolution number 8.
That's a resolution. Resolution can, is this resolution communicated to you?
Subsequently, there was an order that is at page 26.
All right.
In terms of this resolution itself.
You are Mrinal Kanti Das.
Yes, Lordship. The order at page 26, Lordship, whereby
Page?
page 26.
Yes.
Sri Minal Kanti Das, son of so and so, junior engineer of Barpeta Road Municipal Board, he is hereby upgraded as assistant engineer under this municipal board. By resolution number 8 of board meeting held on so and so, in the pay scale of so and so.
Ms. Bhattacharya, how can you say that this order has not been implemented because the chairman has given it?
Lordship, then the answer is there in page 29 of the writ petition. The resolution that they have annexed now.
This is the
Page-
subsequent resolution,
Subsequent resolution.
Correct.
Lordship.
Yes, Lordship.
subsequent.
Lordship, may I read, Lordship?
It's all right. Yes, you read.
Lordship,
Lordship,
office serial number so and so dated so and so applicant Sri Minal Kanti Das, Sri Nitai Sai and Sri Mahananda Talukdar are regular employees of Barpeta Municipal Board. In the resolutions number 8, 9 and 10 adopted on 25/9/2013 by the Barpeta Road Municipal Board, they were promoted as assistant engineer supervisor of electricity department and sweeper and labor supervisor with effect from so and so, and their salaries were to be paid out of the fund of the board until it is released by
No,
the
but this,
government.
this explanation cannot be accepted, Ms. Bhattacharya, because it appears that there have been promotion. Because even this resolution says upon
Lordship, then the
promotion.
next,
You see, it says upon promotion. Now, the problem is that the reason that you are citing,
Lordship.
which is also there in your affidavit, is that there is no stuffing pattern.
Yes,
Now,
Lordship.
this is some lapses in your
No,
department.
Lordship,
Then,
staffing pattern has to be done by the government, Lordship. There is already a decision, but again,
so that's why I'm saying
Yes.
government or the board or whatever, but at the end of the day, once the petitioner has been promoted, he's doing the he's performing the work of a assistant engineer. Why should he not be given the pay scale?
But
Which is
Lordship-
proportionate to his work. Why should he be given the pay scale of the junior engineer? That doesn't appear to be fair. I am on the fairness of this whole thing. I understand you are having some problem, but that cannot be a reason to deprive him his pay scale of the promotional post. Because the issue which is falling for determination in this writ petition is deprival of the pay scale of the promoted post. There is now no dispute. Even in your resolution at page 29, upon promotion, you are agreeable. You are agreeing to that. The only problem you are saying is that had decided not to release the salaries until there is stuffing pattern. Now, when
Yes,
you come
Lordship.
back to your
In
affidavit,
the resolution also
and
there, Lordship.
exactly,
Yes.
and in your affidavit also, you are saying the same thing.
Yes,
In
Lordship.
paragraph 5, was it?
Lordship.
Yes.
Because
The ADC who at that time was in charge
Charge.
of the financial power of so and so board had passed an order not to pay the upgradation salary till finalization of stuffing
Yes,
pattern.
Lordship. This-
So it's an admitted position. There
this
cannot
is
be a
of
dispute.
22, Lordship, resolution.
Whatever. You see, the admitted position is that he has been promoted.
Lordship, then in
But
that,
yes,
in that case, the government or the deputy commissioner, they have to.
who is
take
appearing for
actions.
the government? Who is appearing? You are for the board here.
The board, Lordship, here.
Who is appearing for the government? Where are they? Are they not made parties here?
Yes, yes,
Then,
Lordship.
then
The
where is
deputy
the
commissioner-
state of Assam?
Deputy Commissioner has to,
Yes, State of Assam. State of Assam cannot remain silent.
the Deputy Commissioner. Okay, subsequently, Lordship, the additional Deputy Commissioner has been made a party, Lordship.
Yes, where are they?
Lordship, I'll be appearing for.
Yes, what is this? Where is your affidavit? I have taken up the matter, investing some judicial time in order to dispose it of. You are sitting silent.
Under the impression that she will be.
No,
appearing.
but then matters are listed. These are old matters. All the respondents are expected to look into the briefs and find out their respective roles, because this is the issue here. And the stand of the board is very clear that the staffing pattern has not been done. But that cannot be accepted. The government is also silent. Why should the petitioner be suffering because of all this?
Lordship,
If that was the thing, then you should not have given him promotion. You gave him promotion. Now you're not giving him the pay scale of the promoted post.
regarding staffing pattern, Lordship, there are other matters also pending.
I am not interested in that, Ms.
Yes,
Bhattacharjee. I am only
Yes, Lordship.
applying my mind to the case which is on board before me.
Lordship,
Affidavits have to come from the state explaining what are they doing.
Or date may be fixed so that I can
Thursday,
file my.
Thursday. I need positive instruction as regards the staffing pattern and what is the status. This matter cannot be carried on in this fashion. Yes, Mr. Counsel, you want to say something?
Lordship, at page 47, I have filed an addition, affidavit in reply, Lordship. I have stated, Lordship, paragraph 5, that some other persons subsequent to this resolution taken with regard to the staffing pattern, Lordship, one,
Seema Karmakar,
yes, Lordship. Then one Dhanjit Das and
Gayan Patwari.
Gyan Patwari, those were also promoted and they are receiving their pay scale.
How can that be then?
Yes,
Lordship, that's the instruction I'll
No,
obtain,
but
Lordship. Because there are,
Ms. Bhattacharjee, you see, these are the instructions
No,
which should be
if-
there.
if-
You see,
if
the
there-
issue is that when we take up the matters, we hope we can dispose it of. Otherwise, there is no point. And a lot of, I have a huge number of board and a lot of
they are in
councils
the
are waiting for
clerical
their
cadre,
turn.
Lordship, not.
If you see the difficult, you one time this court is very accommodating.
Lordship,
I don't have any issue of giving you time
Lordship.
if it is for a reasonable purpose. But if a matter is taken up, then it is with the consent of parties. My first question to you all was, is pleadings complete? Was it or
Yes,
not?
Lordship.
The reply was that pleadings are complete. The cooperation should come from the bar also. The judges alone can't keep on disposing of cases after cases if the bar do not cooperate. Yes, when can it be taken up? Please get the clarifications.
Thursday, Lordship.
Heard, Mr.
I am ambitious.
So and so, learned counsel for the petitioner. Also heard M.S.M. Bhattacharjee, learned additional. You're appearing as a standing.
3 and 4, Lordship.
Learned counsel representing the respondent number 3 and 4, so and so board, huh? And M.S.
You, Sharma.
U. Sharma, learned counsel appearing for
1
the
and 2.
state respondent.
5.
1, 2, and 5. The issue involved in this writ petition, the issue involved in this writ petition is the deprivation of the pay scale of the promoted post, i.e. assistant engineer, with effect from 1/1/13. It appears that the stand taken by the respondent board is that due to non-finalization of the staffing pattern by the state of Assam, the upgraded scale could not be given to the petitioner. The aforesaid explanation does not appear to be Mr. So-and-so further draws the notice of this court to the affidavit in reply filed on 22/7/2025, wherein in paragraph 5, specific instances of subsequently similarly promoted officers have been granted the upgraded pay scale of the promoted post. Paragraph 5 of the affidavit in reply reads as under. page 47. It is worthwhile to notice that the state of Assam, though has been arrayed as respondents, have not filed any return yet. MS so-and-so seeks a short accommodation to bring on record the stand of the state of Assam. MS M. Bhattacharjee also seeks a short accommodation to clarify in terms of paragraph 5 of the of the affidavit in reply. It is unfortunate that despite the matter released on Thursday, please have it. Otherwise, on Thursday, I'm going to say something more than this. I'm stopping today here only because the matter is fresh in the mind of the court. I want to dispose it of.
Number 10.
Wait, please, also. This matter pertains to my compassionate appointment, my lord. The petitioner's father, while he was serving as a constable, my lord, in CISF, my lord, he died in the year 1999. At that point of time, my lord, the petitioner was minor, my lord.
Pleadings complete.
Pleadings completed, my lord.
Let me verify.
My lord.
Yes, who is there for the respondents? Heard Mr. S. Das, Learned Counsel, appearing for the petitioner. None appears for the respondent.
2 and 2, 3, 4. That will be CISF, my lord.
On call, huh? When did the petitioner's father expire? 99.
1999.
And you applied when?
I applied on 21/9/2016.
And
I attained majority in 2009. So only on that ground that I was.
but the delay thing will
Yes,
come.
yes, that's why, my lord, the file was returned. If your lordship will.
Then Dibabrata Tiwari.
Yes, if your lordship will kindly see the last page 23, my lord, of my petition, my lord. 23.
Yes.
This is the ground, my lord. It has been seen that in most of the cases, the applicants gain majority too early but not applied for compassionate appointment immediately on attaining the age of majority. In most cases, reason for delay given the applicant was not aware about the rule position of compassionate appointment.
Mr. Das, the issue here is because you compassionate appointment are not
Yes, yes.
so recruitment source of recruitment, right?
Yes.
These are given with a specific purpose.
Yes.
The purpose is to for the immediacy which is involved, right? To ease the suffering and the pain of the survivor of that family, the deceased family, right? Then here, that itself has been negated now. It's been frustrated. Where is the question of granting the prayer now in 25?
Last line that the.
When was your rejection done? This order?
Yes, yes.
That order which you just read?
Yes.
22/218.
Yes, it was returned back with a direction to re-examine. After that, my lord, there has been no communication.
And when did you file this?
It was filed on 2022.
I don't find any merit.
My lord.
Sorry. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking appointment on compassionate ground on the basis of his application dated 21/9/2016. Stop. The brief facts of the case is that the father of the petitioner, i.e., yes, what is the name of the father?
P.R. Miki.
So and so, who was working as constable in the office of the respondent number 4, expired on 20/12/1999, when the petitioner was only 7 years of age. After it is a specific case of the petitioner that after attending majority, the petitioner on 21/9/2016 applied for his appointment in the office of the respondent number 4 on compassionate ground. it is the further case of the petitioner that despite submitting all required documents as directed by the respondent number 4, till date no action has been taken by the respondent authority for appointment of the petitioner. Situated thus the present writ petition. Mr. S. Das, learned counsel appearing for the petitioner, submits that since the petitioner was a minor at the time his father expired, upon attaining majority in when did he attain majority?
30 September
A
2009.
majority on 39
2009.
2009. He applied for the he applied for appointment to the said post on compassionate ground on 21/9/2016.
Yes, ma'am.
He further submits that your name is Rintumedi,
Rintumedi.
that the authorities by communication dated 22/2/2018 though has directed the respondent authorities to re-examine the case of the applicant who gained majority too early but did not apply for compassionate appointment immediately and resubmit the case to the which ministry?
My lord, Ministry of Home, perhaps, my lord.
To the Ministry of, it's given in Hindi. That's why I'm not being able to read. Respondent number
1.
To the respondent number 1. Stop. He further submits that no such re-examination has been done till date. Having heard the learned counsel appearing for the petitioner, upon noticing that the father of the petitioner has admittedly expired on 1999, when the petitioner was only 7 years of age, and admittedly, despite attaining majority on
39/2009.
39/2009, the petitioner applied for appointment on compassionate ground in the office of respondent number 4 on 21/9/2016, this court finds that this case is liable to be dismissed in terms of the decision of the apex court in the case of State of West Bengal versus Debobrato Tiwari, reported in so-and-so, on the ground of delay. Para 30 to 40 of the aforesaid judgment is reproduced hereunder for ready reference. Next, Likhiba. It is well settled law that compassionate appointment is not a source of recruitment and is not a vested right which can be exercised any time in the future. Reading of the aforesaid judgment of the apex court, it is apparent that the object of providing grant of compassionate appointment is to enable the family of the deceased employee to tide over the sudden crisis due to the death of the bread earner, which has left the family in penury and without any means of livelihood. It is thus with this very object that unless some source of livelihood is provided, the family could not be in a position to make both ends meet. Appointment on compassionate ground is provided. However, the same is not a vested right. Thus, where a long lapse of time has occurred since the death of the deceased employee, the sense of immediacy for seeking compassionate appointment ceases to exist and loses its significance, and thereby disentitling the applicant for appointment on compassionate ground. Apparent in the facts of the case that despite attaining majority in the year 2009, the petitioner applied for the compassionate appointment only in so and so. It is also apparent that during the interregnum period, he has been able to sustain his livelihood, and therefore the sense of immediacy has been lost and diluted. Accordingly, there is no merit in the writ petition. Dismissed, no cost.
Lordship, may I pay for listing this matter tomorrow or day after tomorrow?
Item number?
Item number 11, my lord.
এই মাত্র কোনটো বল dispose কৰাটো? 11 tomorrow or day after, yes. When?
Tomorrow, my lord, or day after tomorrow.
As prayed for, day after tomorrow. Yes.
Item number 12.
Wait, Your Lordship.
Provincialization, Mr. Saikia.
Yes, my lord.
Yes. Pleadings are complete?
Yes, ma'am.
Yes, Mr. Counsel, I am re-verifying from you. Pleadings complete or not complete?
Still has not filed. The private respondent has filed.
Private respondent only has filed, we have not.
So then why are you saying pleadings complete, Mr. Saikia?
For this thing.
Yes.
No, so we would like to file our affidavit.
Heard Mr. So-and-so Saikia, learned counsel for the petitioner, Mr. P. Sharma, na? P. N. Sharma, learned, standing counsel, elementary education, seeks a short accommodation to file return in the matter.
Okay.
Yes, 1 week,
2 weeks, that's it, after vacation. After vacation.
23. All right, relist after 2 weeks and a date to be fixed by the registry.
Okay.
13.
Area salary. Yes,
Pleadings are complete in this matter.
Mr. Fukan.
Lordship, we have filed our affidavit, madam.
Why then area salaries have been not given? Since when the area salaries have not been given?
2014.
2014. What is the reason?
Lordship,
And,
as
wha-
far as my department.
Just 1 sec, Mr. Fukan. Mr. Counsel, the petitioner has been working in which post?
In the post of Malsas,
In the post of?
Malsas,
And he has been deprived since 2014.
14 laws.
And current salary?
No.
Nothing.
No.
Yes, what is the reason?
Lordship, we, in our affidavit, Lordship. Paragraph 6, Lordship.
Page.
Page 33, Lordship. With regard to the statements made in paragraph 4, the deponent begs to state that the communication was made from this and with the Commissioner and Secretary to the Government of Assam GAD Department, by 12/3/2015 letter regarding non-availability of budget, Lordship, which is at Annexure 6.
Yes.
Thereafter, Lordship, the petitioner had submitted 2 numbers of representations. And the first representation 1/9/2020, the additional district commissioner account has informed that an amount of 54,000 was paid to the applicant at the rate of 9,000 per month. With
You are
effect
reading
from-
at page 33.
Yes, Lordship. Now 34, Lordship, paragraph 7,
There are 6 and 7 Cs.
1 second.
6 and 7.
1 second. There was some prohibiting of engagement of master role workers with effect from 1/4/93.
Yes, Lordship.
Hence, they said appointment was not as per the guideline as finance. So these were all master role workers. The petitioner. How many petitioner?
One petitioner.
Petitioner was a master roll worker.
No.
No, Lordship, he
He was engaged
was-
against the sanction post as a Malsasi. Page 19 is my appointment.
All right. You wanted to, yes, page, para 5, yes?
7, Lordship now.
No, para 5 received.
5. The correspondence was made by this office with the Commissioner and Secretary to the Government of Assam GAD Department, Dispur, by letter dated 3/9/2014 in pursuance to letter Deputy Secretary to the Government of Assam GAD, Guwahati, dated 13/7/1987. In this regard, Government requested to submit status of post of Masal Chief after creation of.
Where are all this? It's not there in my copy.
Lordship, in the affidavit filed by respondent number
Page 34.
Respondent number 3, Exhibit Lodge.
Something is, yes, no, this is affidavit by respondent number 2. 2 is who? Page 34 is respondent number 2's affidavit. That is why I'm not finding what you're reading here in page 33 and 34.
Also, it is overriding pages. He also started from page 31 and also.
Huh? Yes, now I have, tell me the internal page. Is
There
there
are
any internal page?
There are 6 and 7.
6.
6 and 7.
I'm reading from the affidavit filed by the respondent number 3, Lordship.
Informed that an amount of 54,000 was paid.
Yes, Lordship, to the applicant at the rate of 9,000 per month with effect from April 2019 to September 2019. In response to
Who is
this,
supposed to send the proposal? As the applicant was engaged after the FRBM period.
yes, Lordship.
What does that mean?
June 2019.
Fiscal rule of budget management.
Hmm?
The fiscal rule of budget
I
management.
have not understood the defense. You are a panel advocate, you are a government advocate.
Government advocate, Lordship.
Yes. What is it? What is your stand? Reading the affidavit, even we can also read affidavit and start disposing of. Yes. What does
Lordship,
it
in this
mean?
affidavit also, the statements are not very, Lordship, to the.
Who has written the affidavit? It's your department. You are the government counsel. If the affidavit is not clear, then what is to be done? Miss Counsel, if you are appearing as a government counsel, you must appear with certain responsibility. You are not here to just read averments of the affidavit. Flipping through the pages will not do any good now, Miss Counsel. You want some time?
Yes.
If you require to file anything additional, please find it. If you file it next week. Heard Mr. So-and-so, learned counsel for the petitioner. Also heard MS. U. Sharma, learned counsel, appearing for
Respond number 3, Lordship.
respondent number 3. And Mr. A. Fukan, respondent number 2. Mr. Gogoi, you're also there. Mr. Gogoi for so-and-so, respondent of finance. Huh? Number, you have the number? Additional senior advocate. As an additional advocate general, would you appear or standing counsel? Huh? SC Finance.
4 and 5.
4 and 5. Huh? Now, the issue involved in the writ petition is not non-payment of the area salary, which is to the petitioner, which is due since the year 2014. Upon MS so-and-so Sharma, learned government counsel, taking this court through the paragraph 6 and 7 of the affidavit in opposition, it appears that certain clarification is required.
If requirement.
Clarification is
Yes,
required,
Lord-
not required.
Lordship.
In view of the same, relist on such and such date. How, the respondents are at liberty to file additional affidavit if so advised.
Yes.
Give a date next week. Try and understand the averments before you
Lordship.
place it before the court.
Yes, Lordship.
And if you,
I apologize.
no, that's all right. And you seek the instruction,
sir.
then it will come. All right.
15.
Yes.
The pleading is completed, my lord.
Cancellation of candidature for post of constable.
Yes, appointment, my lord.
Appointment. Yes, why?
Lordship, I am for the respondent number 1. I am appearing on behalf of Mr. S.S. Roy, Standing Counsel CVC. Lordship, for some personal inconvenience, he couldn't appear before this honorable court, Lordship. Kindly fix it after 18th.
Date may be fixed, my lord. There, my lord.
As prayed for by MS so-and-so on behalf of Mr. S.S. Roy, Learned Standing Counsel CGC, released on such and such date. Your name, give your name also.
22nd.
Obliged.
Item number 16.
May I please, Your Lord? Also, in this case, the present petitioner has alleged his promotional benefit, which has not given to him, my lord.
Promotional benefits.
Benefit, my lord, from junior engineer to assistant engineer. So the present petitioner was appointed in the year 2009, my lord. As per Assam Town and Country Planning Service rules, if a person completed his 5-year term, he is eligible to get his promotional benefit.
5 years. 5-year term.
5 years term, my lord. But in this case, the respondent number 7 here, the respondent authorities has taken initiative to give him promotional benefit. Though the respondent number 7 is junior to me, my lord.
No, sorry, I didn't follow you. So there is some notification
My lord.
which says notification, which says 5 years term, you get the promotional benefit.
Benefit.
Now, this is not given to you, but to respondent number 7,
7.
despite he being junior to you.
Junior. To
This is your case.
my lord, my lord.
Yes, what is your stand? Why are you looking that side? I'm asking you.
Lordship,
Huh? What are you looking for?
Lordship, I am for the respondent number 7, Lordship.
Private respondent?
Yes, Lord.
Yes, where are who's appearing for the state or the respondent? Yes, state respondents.
His Lordship,
State respondents, Ms. Bhattacharjee, Ms. Sharma.
in Ayala. Lordship,
Last time TC Chutia had appeared, additional senior government advocate.
Lordship, regarding the petition.
You are the private respondent,
Yes,
so
sir.
just 1 second, please.
Okay, Lord. 19. It's 16. 16.
Lordship, can it be taken up after some time, Lordship? I'll just open whether TT Chutias he is available or not. Lordship.
All right.
Item 17.
This is a case, Your Lordship, where we have challenged the order of disciplinary.
Yes,
the
Mr.
records
Gogoi,
we-
affidavit.
Yes, the records we received on the last occasion, so I'd like to file an affidavit based on this records, Your Lordship.
You have received the record.
Yes, we received the records.
Heard Mr. S. Bhattakur, Learned Counsel appearing for the petitioner. Also heard Mr. R.R. Gogoi, Learned Counsel appearing, Learned Standing Counsel, Standing Counsel PHE. Stop. Mr. So-and-so of Standing Counsel PHE submits that he has received the records pertaining to the issue in hand and accordingly seeks a short accommodation to submit his return. Submit the return, not his return. Submit the return. Prayer is allowed 2 weeks.
After 2 weeks.
Relate after 2 weeks on a date to be fixed for the registry.
Obliged.
Item 18.
Obliged.
Yes.
May please, Your Lordship.
Ms. Barwa, affidavit.
Complete Lordship. Kindly fix it for admission hearing another date, Lordship.
Why another date? What is the issue?
My issue regarding withdrawal of the provisional appointment of the petitioner.
Withdrawal of the provisional appointment.
Appointment of the
You're
petitioner.
not prepared today.
I have missed the rejoinder affidavit, Lordship.
All right.
Kindly.
No problem. When do you want it, Ms. Barwa?
Your convenience, Lordship.
No. By when will you be prepared? Thursday
This
or
Thursday-
Wednesday?
This Thursday.
Friday? Huh?
Friday maybe.
Friday?
Yes, Lordship.
Okay. As prayed for, list on from.
Item 19.
Statement of affidavit has not filed, pleading is not completed.
Yes.
Lordship, here I have received an instruction, Lordship. A fresh proposal has already been received from the District Elementary Education Officer, Dhubri, Lordship. So it is under verification. Once that verification is completed, then subsequently.
What was the claim? Arrear.
Arrears, Lordship.
So the proposal is already
Yes.
is under process.
It is under process.
Under
At the
process.
office of the director, Lordship.
So we'll have it after some time then. Heard Mr.
R. Islam.
R. Islam, Learned Counsel for the petitioners. Also heard Mr. P. N. Sharma, Learned Standing Counsel, Elementary Education. Stop. Mr. So-and-so submits that the the area proposal in respect of the lower primary school teachers who are appointed on 28/6/2016 under the Block Elementary Education Officer, Goripur, which includes the services of the petitioners, is under process,
Under verification.
is under verification.
Lordship.
And upon the same being completed,
Yes.
the salary, if so entitled, shall be released to the petitioners. In view of the aforesaid, so can we not dispose it off with a direction to,
Verify the matter and
Otherwise, Lordship may direct.
because that is your,
Lordship, it is under verification if they are in fact. Lordship.
which you have that copy?
Lordship.
Sure. Heard, no, sorry, সেইটো লিখিলা না? By way of this petition, এই মাজৰ পাৰ্টটো নালাগে আৰু. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking release and disbursement of the arrear salaries of the petitioners for the period with effect from 1/7/2016 to 28/2/2022. The brief facts of the case is that how many petitioners?
40 minutes. 41. 41.
The petitioners were appointed as assistant teachers at various lower primary schools under the Block Elementary Education Officer Goripur in the district of Dhubri, Assam, on purely temporary basis in the pay band -2 within bracket PB-2 at the rate rupees 5,200 to 20,200 plus grade pay rupees 2,500 per month plus other allowances as admissible under rules against the government sanctioned post by common appointment order dated 27/6/2016 issued by the respondent number 2. Stop. Accordingly, the petitioners joined in the duties as assistant teachers within the 15 days of their appointment order dated 27/6/2016 in the respective lower primary schools under the respondent number 3. And since then, they have been serving as assistant teachers of the respective schools, receiving the current monthly salaries. Stop. However,
Page 27 minute can be seen.
page
Page 27 minute. Reason behind this. Page 27 minute. And exercise C,
yes.
why they are entitled.
Hmm?
How they are entitled to.
No, no, I'm not on that now because we are only on the. I'm not giving it
Yes.
disposal on merit, right?
Yes.
So now your dispute was to the arrear salary. So since they were giving you the current salary, when did they stop? Then how does due accumulated?
No, my lord, current salary is going on, my lord. It is the, my lord.
Refixed. Refixed.
Yes, ma'am. That is why, my lord, I am the question number 27.
So you are not receiving the benefit
Yes.
of the refixation.
Yes, my lord.
However, the petitioners have not been receiving the benefits of refixation of basic pay of order dated 9/5/2022. Correct? This, huh? At page 27, what is the order date? Now, issued by the Government of Assam Finance PRU Department as assistant teachers of lower primary schools under the so and so. Huh? It is no, Mr. So and so submits that since the petitioners have not been given the benefit of the enhancement of salary by way of refixation in terms of the order dated 9/5/2022, the present the present petition has been filed canvassing the aforesaid grievance before this court. Mr. P.N. Sharma, Leonard so and so submits that pending adjudication of the instant writ petition, the Office of the Director of Elementary Education Assam received the area salary proposal from DEO Dhubri in respect of petitioners and 40 other similarly situated LP teachers. However, upon verification, it was found that initial pay fixation order copy was not included with the aforesaid proposal, and therefore the benefits of the refixation is yet to be released to the petitioner. He further submits that as per the instruction received by letter dated 11/9/2025, the in terms of the letter issued by the Director Elementary Education Assam Kahilipara, DEO Dhubri has submitted the documents called for, including the non-royal certificate for the relevant year, and accordingly a fresh proposal has been received in the said office. He further submits that after completion of the verification process, the amount of area shall be paid to the petitioners concerned. Having heard and considered the above, it appears that the process of verification is in progress, and as and when the same is completed, the amount of area as due to the petitioners shall be released. Apt to refer to the instruction so and so, which reads as here under DDBA. I report to DDBA that which is kept on record and marked as X. In view of the aforesaid endorsement made by the learned counsel appearing for the state learned standing counsel Koidima, vis-a-vis the instruction, this court in the interest of justice deems appropriate to dispose of this writ petition by directing the respondents to complete the verification within 2 months from the date of receipt of the certified copy of this order, and upon the same being completed, the petitioner, the area salaries be released to the petitioners in accordance with law. This allowed, huh? Disposed of, not allowed.
Item 20.
Also, in item 20, I pray for some accommodation. Item 20, I may be allowed to grow.
Withdraw. He wants to withdraw and you want to find something? Now tell me, which prayer should I allow? All right, all right.
Inadvertently.
Heard, Mr.
Islam.
You want to withdraw the petition?
Yes, with the liberty to file a fresh.
Heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. P. N. Sharma, learned standing counsel, elementary education. Mr. A. Chalia, learned standing counsel, finance. And yes, anyone else? MS Fukan, na? K. Fukan, learned counsel, learned government counsel or additional? Government counsel for respondent number 4. Mr. So-and-so Islam, learned counsel for the petitioner, submits that he has received instructions from the petitioner to withdraw the instant writ petition with liberty to file afresh. In view of the developments which has, you said some development, yes, no? In view of the developments which has taken place in the meanwhile. Yes. In view of the aforesaid endorsement, the writ petition stands dismissed on being withdrawn with liberty to file afresh, if so advised.
Oblige.
21.
Right, Your Lordship.
Yes.
Okay, right, order dated 19/7/2025 in I 2187/2025. Director of Secondary Education was impleted, and accordingly we have filed the amended cost title on the last.
Who is appearing for the newly impleted? Yes.
Okay, however, our name is not reflected in the cause list.
And would you be also filing something, or you want to make that prayer after your name reflects in the cause list?
Lordship, after, because we have not gone through the petition, Your Lordship.
Ms. Mushahari,
Lordship.
please understand
Lordship.
the question that has been put to you. You want to make the prayer for filing affidavit after the name is reflected in the cause list.
Yes, Your Lordship.
Why? Please think again. I understand your name is not reflected. I will certainly direct the registry to reflect your name on the next. But if you want to file an affidavit, please ask. These matters cannot be just listed for one day for showing your name and on that date again to give you a liberty to file an affidavit. You want your liberty, you ask.
Yes, Your Lord.
Do you want to file?
Yes, Your Lord.
Heard, Mr.
A. Barua.
A. Barua, learned counsel for the petitioner. Also heard Ms. D. Mushahari, learned counsel appearing for the newly impleted respondent number
8.
8. MS so-and-so seeks how much time?
3 weeks. Your Lordship.
3 weeks' time to file affidavit in opposition in on behalf of the newly imputed respondent number so and so. Prayer is allowed. Relist after so and so. Let registry reflect the name of the learned counsel appearing on behalf of the newly imputed respondent number so and so in the cause list.
Other respondents have also not filed.
In the
elementary-
meantime, if the remaining respondents are so advised, may also file their respective return in the matter. You have not served her a copy?
Yes, sir.
Ms. Basari, have you received the copy or not?
Lordship, till now we have not received because.
Please give her a copy. Yes.
Lordship, here we had filed our affidavit, your Lordship. It was filed on 11th of this month, your Lordship. However, it's not on record, your Lordship.
Heard MSA Begum, learned counsel for the petitioner, also heard MSD Mushahari, learned standing counsel, secondary school education department. Hey, our matter to do, koi dipo, huh? Huh?
Your Lordship.
One second. MSD Mustahari, learned standing counsel, submits that though affidavit in opposition has been filed in the matter, has submitted affidavit in opposition when?
11/9.
On 11
9.
9
2025.
2025. Stop. It appears that the same is not on record. However, MSA Begum so and so submits that she has received the copy of the same and seeks a short accommodation to file rejoinder. Prayer is allowed. Let registry verify and place the affidavit in opposition filed on behalf of the state and place the same on record. Relist after 2 weeks or 3 weeks?
No, 1 week after. Your Lordship.
After 1 week on a date to be fixed by the registry. In the meantime, the petitioner shall file the rejoinder as prayed for.
Obliged.
Yes,
Yes, Lordship. Lordship, they have not filed any affidavit.
they have not filed.
Yeah.
Who will file? CGC.
CGC, Lordship.
Yes, CGC. Now CGC is also not there. After some time, get hold of CGC.
25 to 29.
My President also. The Honorable Court Lordship, similar passed a judgment by whose directed the government to provincialize the service of the within a period of 4 months, Lordship, similar to the petitioner.
You want a similar?
Yes, Lordship.
Have you given a copy to Ms. Mushari? Have you seen it?
No, your Lordship.
Then you have a look at it. We'll call it after some time. See if it is covered.
No.
After some time.
Item number 30.
Yes.
May I pray your Lordship?
Provincialization.
No, Lordship, here.
Sorry, pension. Provisional pension.
Provisional pension. That's it.
Affidavit.
Okay.
Huh? And you're smiling.
No, very new matter.
Pension is very
I understand,
important.
Lordship, and he's already been retired.
Huh?
And so.
How will he survive?
No, basically this later revenue department answered this because he was a lot model at a time when.
Where is revenue? Yes, revenue. Are there any shortage of the panel councils today?
Secondly, Lordship, I can appear for deputy commissioner, so as he was a lot model. So let me get the instruction from deputy commissioner too.
All right. Heard Mr. DC Nath, learned counsel for the petitioner. Also heard Mr.
CKS Budwal.
CKS, na?
CKS.
CKS Barwa, learned
Yes, sir.
government counsel for the state. Mr. So-and-so submits that instructions are still awaited. It appears that the provisional pension as claimed by the petitioner is still not granted by the authorities till date. Mr. So and so. It further appears that though on 26/2025, this court granted an opportunity to the learned government advocate to obtain instruction as regards the non-release of the provisional pension to the petitioner. Till date, no instruction has been placed before this court. It further appears on last two occasions also, I 11/8/2025 and 29/8/2025. Time has been sought. However, today as well, when the matter has been called, the respondent counsel is seeking further time to place the aforesaid instruction.
That point, correspondence was being sent. Correspondence was sent to one of our council.
I am not concerned with that. We were asking for instructions and you were asking for time.
We'll file the affidavit. But there are some.
Our relist, give him Monday, huh? Relist on Monday, so and so date. In the event, the positive instruction and or the affidavit in opposition is not filed before this court, the concerned respondent officer shall be present personally in the court.
Problem. Item number 31.
Lordships, I find an additional.
I cannot recognize you.
Sorry, Lordship.
Yes, Ms. Chaudhary.
Lordships, I find an additional affidavit today. It is just coming before the
Oh.
court. Can it just be taken up? after
All
the
right.
provide? May I also request the presence of Mr. Kayal in the matter, Lordship? I am
Lordship,
going to
sir.
pay.
I shall not be able to secure that,
No,
but you
I-
can make
I-
a request.
A request.
Lordship, he has some personal difficulty to the Lordship.
In
Huh?
case I will
He
be
has some
doing the
personal
matter,
difficulty
Lordship.
to the Lordship.
I will be doing the
Also-
matter.
All right, let the affidavit come.
Let me just
Yes.
deeply obliged.
Item number 32.
May it please your lordship, my lord, I was appointed as a president of the managing committee at page 16,
Page.
16.
Pleadings complete.
My lord, they had to bring the records. The reason was
Yes.
because my lord, the impugn order at page 20 will say that my lord at 16, your lordship may look.
Page, Mr.
16.
Roy Chaudhary. 16. Yes.
President education in term of 5 years or before 5 years for reasons to be recorded in writing.
Page 16.
16. A,
Huh?
A, left hand side A.
Oh, okay. President.
I can be removed prior to 5
For
years.
terms of 5 years or before 5 years for
for
reasons to be recorded in writing.
So
Yes.
I am Dr. Raman Talukdar.
Okay.
Then at page 20, my lord.
So before 5 years, they have to, if removal, it has to be reasoned and recorded, right?
My lord, at
Yeah.
page 20. Page 20, now new president has been listed in page 20.
Page
20.
20. Yes.
My lord, so there was an interim order of status quo. My lord, the records are to be produced by the government. What are the reasons and the reasons has to be communicated. My lord, reasons cannot be kept in the locker. Reasons to be recorded means, my lord, in writing that has to be communicated. Without a communication, a man cannot be removed. Even the rules also provide that. my lord.
So here they have not communicated the reasons.
No reasons. I don't know what is the reasons.
No, where did you, where does it indicate that reasons are there? You
My lord.
just read something in page 20?
Page 20 also, my lord, similarly at A, president in terms of 5 years or for 5 years for reasons.
No, but now where is the removal?
That is the removal. New person has been in the threat at page.
Where? Page 20?
Page 20. Now a new person, Sumanto Bhattakur, has come in place of me. Previously, Dr. Raman Talukdar was there.
By replacing the existing so and so of the so and so. Yes.
The government has to.
Yes, where are the reasons?
That is to be brought on record by the.
You are
government.
for this person?
Yes, I am for this.
Yes, government. Where are the reasons? Mr. Dar, yes.
It's a higher decision, madam. I don't know.
It is a. So who, I am only concerned with who is appearing. He's not here. So we'll have it after some time. Mr. Raj Chaudhary,
Malad.
what is to be done?
Malad.
They are not here, the council.
Sometime or someday.
Malad, let it come on Monday and.
All right, as prayed for list on such and such date.
On Monday. Let it come. 19th.
All right, 19th.
190.
Sober presence too.
Interim order to continue.
Interim, if any, shall continue till the next date of listing.
Obligement.
Handling item number 31.
Affidavit has come.
Yes, Your Honor. Yeah. Lordships, what has happened in the matter is that the petitioner of your Lordships is a professor, is an assistant professor in the Assam University of Silchar campus. And he has been, there were charges of sexual harassment against him. And pursuant to such charges, he was placed under suspension. So on the first occasion, the ICC held a meeting with him sometime in the month of December, on 4th of December 2024. It is only thereafter on
I'm
18th.
not able to hear you clearly.
Lordship, should I remove the mask in that case? Your Lordship, kindly permit me.
No, I have not asked you to put
No,
it
Lordship,
in the
I'm not
first
a little
instance.
unwell, and these days it's a little, people are very
Yes.
skeptical about things. So
If you are comfortable, yes.
Lordships. So on the last occasion, what has happened is on 18/12/2024, the petitioner has been placed under suspension. Now, pursuant thereto, after a lapse of almost a month and a half, they initiated a DP against him.
The petitioner was holding what post you
He's
said?
an
Mr.?
assistant professor in the Hindi department at the DFU campus at Silchar University.
Assistant Professor Difu.
DFU, yes.
Yes.
In the Hindi department. Now,
He was removed on the allegation of sexual harassment.
Yes, Your Lordship. He was placed under suspension on the grounds of, the entire case revolves around suspension, Your Lordship. Now, Your Lordships are aware that once a person is placed under suspension, the reason behind such doing is perhaps to ensure that he doesn't tamper with the evidence, or in this particular matter, the victims are not made, to
You are
be
challenging
insecure.
the suspension order.
Yes, Your Lordships.
I-
In challenging the pursuant extension of the suspension.
That has been
that has been
extended.
extended.
With a reasoned order?
No, Your Lordships. No reasons assigned. And that was the entire, the reason why we had approached this.
So
honorable
this
court.
is central government
On-
that CC's rules are there, I think.
Yes, Your Lordship.
Then
Mr.
Deepak Mali's case.
Deepak Mali's case, Your Lordships, Ajay Chaudhary's case, this
Will
law is
come.
very well settled. Now, I just.
Which is that extension order?
Page 73, 10/3/2025, Your Lordships.
Page 70.
3.
This has come up today for admission.
Yes, Your Lordships. Sadly, what is happening is, Your Lordship, on the last three occasions, my learned friend has been appearing and saying that the entire inquiry proceeding is over and the report will be placed very shortly. Now, although I am told that the report is already ready, they have again placed me under suspension, again without any review or any other orders, reason order. That is what I have brought before this honorable court by way of the additional affidavit.
That order 14/8/25. No, that is the court's
Page
order.
73, Your Lordships, page 73.
No. Again,
affidavit?
that's
Yes.
174.
Yes, Your Lordships. Yes, 170.
This is the third time
This is the
or second time?
third time, Your Lordships. Again, without any orders. Any cogent reasons being recorded over there. I may just be permitted to read the order, Your Lordships. Whereas a disciplinary proceeding against the so-and-so, Department of Hindi so-and-so is pending, and the order of suspension is in force, while order dated 10th of March 2025. Now, therefore, subject to ratification by the Executive Council of the University, the competent authority in exercise of powers vested under
Yes,
so-and-so.
Mr. Counsel, yes, who's there? Yes,
Mr.
Ms. Counsel.
Kayal is the one who is the.
Now,
answerable person.
prima facie, it appears there are no reasons. Which is the first, prior to this, which is that page?
Page 73 of the writ petition, Your Lordships. Annexure G. It is absolutely verbatim, Your Lordships.
Yes.
Same order.
Lordship, I am appearing for respondent 5, UGC. We are just formal parties, Assam University.
Where is CGC? You are for UGC,
UGC.
Mr. Kayal.
No, Lordship, I am for Dr. P. Agarwal.
No, but, and who is the main respondent, Miss Chaudhary? Who is going to respond?
Mr. Kayal is the one, Your Lordship. He is the standing counsel for the Assam.
Where is his
University.
junior?
Now, he was just here and we've just informed him, Your Lordships. No, the problem, Your Lordship, which has occurred is that although I had not alleged malafide at that, when I had challenged this instant writ petition, what is happening is they're deliberately not providing me a copy of the report, or they're not passing any orders thereon. And I'm told that they will be passing the orders only on the 25th of September. On 27th, the university closes for 3 weeks. So I am left without any remedy to challenge or to whatever.
All right, I'm taking this matter tomorrow, Miss Chaudhary.
Yes, Your
Yes, please inform.
Very good.
But I think, Miss Chaudhary, please ask your junior to get hold of Mr. Kayal's junior so that I pass this order in his presence.
He's just coming, Your Lordships. He was, I think, on legs in another courtroom.
All right, I'll have it in after the next
The
matter.
next-
Just
I-
wait for.
Yes.
Miss Counsel, don't go away. Wait, I'm taking it up. Yes, next matter.
Yes.
May it please your lordship. Today we have received, my lord, affidavit in opposition.
You want to file a rejoinder?
Yes, my lord.
As prayed for by MS so-and-so, learned counsel appearing for the petitioner, relist
On
after-
any date after vacation, my lord.
after 3 weeks on a date to be fixed by the registry to enable the petitioner to file rejoinder against the affidavit in opposition filed by respondent number, respondent number 2.
My lord, my lord, respondent of finance, my lord. They are the main respondent.
In the meantime, the remaining respondents, if so advised, shall file their respective return in the matter.
Yes, obliged.
53.
Yes, Khandigar, Mr. Khandigar, yes, pleadings, it doesn't appear anybody has filed anything, right?
Has not filed. ma'am.
Huh?
Not filed.
Yes.
Lordship, affidavit not required because the
Not
coordinate
required.
bench has already decided this matter, Lordship.
If
May I pass? Yes.
appointment on compassionate ground.
My lord. In this case, my lord, my case has been recommended by the district level committee. Now, this, my lord,
One second. What is the ultimately in this decision? So here this case has in this decision, Ms. Bhattacharjee, it has been rejected on ground of delay.
Delay, Lordship.
Delay.
Yes,
Now-
here also, Lordship, the same
Ms.
thing. Yes,
Bhattacharjee,
Lordship.
why are you in such a hurry?
Yes, Lordship, this is on
You see,
ground of
even
delay.
this court has authored various judgments on compassionate ground, even today morning ones on ground of delay.
Lordship.
So now that you are saying that I should dispose it of in terms of this coordinate bench, that is why I'm trying to understand.
Lordship.
What is the significance? Is this petitioner also, if the same department, is it that similar? Or is it because of Dibabrata Tiwari you are asking that relief?
Yes, Lordship.
Because I have also authored.
Uh,
And even today morning I have.
Lordship, first of all.
So I'm trying to understand the in what context you have made a submission before this court to
Yes,
dispose of this
Lordship.
matter in view of the decision of the coordinate bench. In what context?
Lordship, firstly,
Yes, in what context?
Lordship, the date of death is in 2008 and admittedly, Lordship, the application is in 2021, Lordship.
That is the delay.
Yes,
That is
Lordship.
Dibabrata Tiwari.
Debabrata Tiwari.
Yes,
track,
that is the
Lordship.
genesis.
Yes, Lordship.
Yes.
And
Based on that, several
judgments
judgments have
been
come,
passed. Yes, Lordship.
including this court.
Yes, Lordship. So on
Then-
this count, Lordship, I
But
pray
the
that
significance of just giving this judgment, that is what I'm trying to understand.
Lordship, this is very recent, that's why, Lordship, because an executive order has also
You are
been
not
issued
here
by
from
the-
10:30 in this court.
I was there, Lordship.
Because this court has also given one. I think, Mr. Barwa, in your case,
Item number 10.
item number
10.
10.
Here, my lord.
Yes, now tell me, when did your father?
My father, my lord.
When?
Died on 4/10, 2000.
4? Yeah, item 10 or number.
4/10,
4?
2008.
2008.
My lord.
Yes,
Then my mother made application.
when?
Mother made application 16/10, 2008.
1610?
2008.
That was rejected.
No, nothing has.
Nothing happened.
Then I have applied
When?
after attaining the measure.
When?
I have applied on my lord.
In fact, Mr. Barwa, this is similar to your case in the morning, attaining a majority.
On 2012, 2021.
20?
12.
Yes.
Then my,
2012, 21.
then my lord, the DLC held on 21/12/2021.
21, 12?
2021.
Hmm.
And recommended my case as an special case, my lord.
Recommended. Then,
My lord, page 45, without placing my case before the SLC, the commissioner, my lord, the deputy secretary to the government of Assam has rejected my case. He has no authority.
that is when?
He has rejected on 13 April 2022.
13 April
2022.
22.
Here, my lord.
Page 45. Let's see, page 45.
Interim order, page 49, my lord.
49.
Page 49. He ought to have placed the before the SLC. Without placing SLC, he himself rejected. He cannot. Page 49.
Yes, what do you have to say to this? Is this the issue involved here is about the rejection by the deputy secretary to the government of Assam, who is not a competent authority? Is this issue covered by the decision of the coordinate bench, which you just given to me?
Coordinate bench also, in that case, the DLC recommended Lordship.
And
Then,
rejected by another authority?
Yes,
Which?
another authority.
Which?
Because
Which authority?
in that case, this was SLC Lordship.
Then that is the competent
It was
authority.
SLC.
Ms.
And Lordship-
Bhattacharya, that's a competent authority. Now, here you please impress the court now, how this person has the authority without placing it before the SLC to reject it.
Then,
That is the issue involved.
then Lordship, there was a notification regarding the compassionate appointment on September 2024, Lordship. And subsequent to that, there was a judgment of this honorable court, which was a common judgment and order.
Ms. Counsel, I'm not asking about the judgment. I'm only asking a very specific query.
Lordship.
How, because I can understand the DLC and the SLC rejecting, recommending, I can understand.
Lordship.
After the DLC has recommended,
Lordship.
it should have been placed before the SLC in terms of your guidelines,
Lordship.
right? Now here, it was not placed before the SLC, but Deputy Secretary to the Government of Assam has
WPT
on its own rejected. Now that part you need to explain. Where does the Deputy Secretary to the Government of Assam derive that power? He may have some, it may be there in some guideline. I don't know. It is for you to show before the court.
Standing counsel for.
Yes, Mr. Dhar. Can you show some light? Yes.
My lord, if we go by the law, my lord, the law settled by Supreme Court long ago, whether my lord, a minor attaining the age
I'm
of.
not on that, Mr.
My lord,
Dhar.
this is the crux of the.
See, Mr. Dhar, that is a different aspect. When a specific query is placed before the councils, you
My lord.
answer. If we don't start.
My lord.
So that means there is no such power. Now you want to bring in the delay aspect and say there was to have been no use placing it before SLC because of delay and therefore.
No, my lord.
So I am just trying to figure out what is
I am not
happened.
trying to figure out, my lord. I'm just reading the order.
So then,
No, my lord,
Mr. Khanikar, you have a look at it, relist tomorrow. Yes, next.
MD.
Have a look at it
No, my lord, I just want
tomorrow.
to read it, my lord.
Tomorrow you have a
Because
look at it properly. Yes.
There is a case
Next.
in this order only itself, my lord.
Mr. Dhar, tomorrow.
Standing item number 31.
Yes.
Can I fix only questions? So.
We're having it tomorrow.
Lordship.
Heard MS R. S. Chaudhary, Learned Counsel, appearing for the petitioner. Also heard Mr. K. Jain, Learned Counsel, appearing for Assam University. And MS S. Nath, Learned Counsel, appearing for UGC. UGC, stop. MSR S. Chaudhary, by drawing the attention of this court to the additional affidavit filed today, I so and so did, submits that the suspension of the petitioner has been extended third consecutive time without giving any reasons thereof. Mr. Suensu Jain, however, submits that since Mr. S.E. Kayal, Learned Standing Counsel, Assam University, is not present today in court due to personal difficulty, the same may be the case may be taken up tomorrow.
Can it be taken day after tomorrow?
Then a lot of matters might be there. I'm all right. Subject to
On day after tomorrow, date to date, on such and such date. It is needless to be clarified that since urgency has been canvassed before this court by the petitioner, there shall be no further accommodation given in the matter.
Item 55.
May I please, your lordship. Lordship, matter pertaining to lordship, a promotion to the post of headmaster, lordship. Petitioner is a lordship senior most graduate teacher, lordship. He has been lordship receiving graduate scale of pay from the period of 1998, lordship. Lordship, the authority lordship made a selection, my lord, violating the rules of 14 of the Assam lordship, 2013 rules, lordship. Lord, it is a covered case, lordship, and lordship, I have filed my.
Who is appearing for the other side?
My lord, Rita Dash Boro.
Huh?
ID Boro.
Where are they?
Lordship, for a moment, lordship, kindly see page.
Yes, but where is your counterpart?
Count, my lord.
It's a 25 matter. All
Lordship.
right.
Lordship.
Monday. None heard Mr. So-and-so. None appears for the respondent BTC on call. Released on Monday. Section 30.
Under 3 occasion, lordship, they met this lordship.
If they don't appear on Monday, we shall proceed. It is needless to be clarified that if there is no non-representation as on Monday as well, the matter shall proceed in accordance with law.
Lordship, can it be Friday?
No. Next.
Item number 56.
May I please, your lordship?
Yes.
Lordship, this is a case where the petitioner has been asked directed to superannuate on 34 to 2025, and during the pendency of this particular case, your lordship, while his date of birth has been recorded wrongly as 31 January 1965, whereas his correct date of birth is 11/4/1960.
31/9.
The wrongly recorded one is 31st January 1965.
31st January 1965. Yes.
Yes.
And the correction should be?
The correct one is 11th April 1969.
This is for correction of date of birth.
Lordship, we also want to know on the basis of what document they have given this date, because all the, while I had joined the
So,
course on
who is
1991.
appearing for the other side? Yes. Who's appearing for the other side? PWRD? Ardhar? PWD? PWD or PWRD?
It's PWD.
Yes, Mr. Dhar? Mr. Dhar, are you appearing in this matter?
My friend was supposed to.
Anyway,
I'm
I think the affidavit is still awaiting.
My lord, I have received the instructions, my lord.
So you'll file it?
I am filing it, my
All right. Heard MS Pidas,
Pidas, your lordship.
Learned Counsel appearing for the petitioner. Also heard Mr. R. Dhar, Learned Standing Counsel, PWD. Mr. Dhar submits that the instructions have been received and accordingly seeks a short accommodation to place the same by way of return. Prayer is allowed, released after 3 weeks on a date to be fixed by the registry.
Lordship, can a date maybe?
It will be given, Miss Counsel. Yes.
Obliged to lordship.
Please, your lordship. My lord, this matter relates to compassionate appointment, my lord. The petitioner's father died on 17/12/2014. He applied on 13/2/2015.
Father, right?
Father, my lord.
Yes.
And the DLC
No, applied when?
13/2/2015.
13 to
2015.
15 immediately.
Yes, madam.
And DLC?
DLC decision is dated 30/11/2023, page 58 of my additional affidavit.
DLC rejected or
No, my lord, there is
recommended?
Yes, my lord.
And then?
And there is here, my lord, instruction was sought from the department regarding the vacancy in any other department. That is reflected at page 58, my lord, of my additional affidavit.
Yes, what happened? Who's appearing?
Because there is no.
But the problem is that there has been a gross delay.
No, my lord, there.
No, the father expired in way back in 14. You see, whatever, whosoever's fault, Debabrata Tiwari has made it very clear. It's not a source of recruitment. There is no sense of immediacy here. Because till now, the petitioner has survived in the interim. Then
Earlier he approached, my lord.
I know, but the facts still remain, Miss Counsel, that we are in 25 now. And the death had taken place in the year 14. This whole interim period, he has survived. So that sense of immediacy has been diluted. Whosoever fault, I understand that you had immediately filed your application. In fact, DLC took there was lapses as far DLC is concerned, because from 15 they took they finally considered your case in the year 2023, and then they were seeking for verification for vacancies, right? I understand, but how can the court overlook the delay part?
My lord, this is covered by one order of this.
Sure.
Yes.
Now, here, one minute. Yeah. In page 58, which is the petitioner number at serial number? 4.
Sorry, my
Niloy
lord.
Das.
Sorry, my lord. It's at the top, my lord. Abdul Ahad.
Abdullah.
At the top, my lord.
No. Yes, what is your stand, respondents? Who's appearing?
Your lordship. DLC has considered, your lordship. Now it will go for consideration to SLC, your lordship.
Yes, what happened then? Why has it not been placed?
Yeah, regarding that, I have to take instruction, Your Lordship.
How much more time? Because there's been already so much delay.
Yes, Your Lord.
Tomorrow. You get the instruction by tomorrow, Ms. Fukan.
Day after tomorrow, Your Lordship.
Day after tomorrow. As prayed for, Lili's day after tomorrow. You remind me, Miss Council, day after tomorrow.
58.
58 is also.
Same.
Yes.
Miss Fukan? 58 also same.
This one is considered by DLC, now it is recommended for SLC, Your Lordship, it's instruction in there.
So then SLC should just pass whatever they want to do.
Last one, Your Lordship.
Give me the petition condio. Next case too. Item number
58.
So, Ms. Fukan, this can be disposed of. Heard MS. So and so, learned counsel appearing for the petitioner, also heard MSK Fukan, learned government counsel, learned state counsel. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking inter alia direct inter alia for direction to the respondent authorities, more particularly the SLC, to consider the proposal of the petitioner as per the recommendations made by the DLC Karimganj on 30/11/2023 for appointment on compassionate ground. Stop. The brief facts of the case is that the petitioner's father, right?
Yes, my lord.
Where do I see which paragraph I'll find these
There are
details?
two, my lord. Page 7.
Petitioner's father, late Niranjan Das, who had been working as a head teacher of Jobainpur LP School in the district of Karimganj, died in harness on 7/11/2016, and thereafter the petitioner on 4/1/2017 submitted an application for appointment on compassionate ground. Stop. Subsequently, his case was placed before the DLC Karimganj, and the DLC Karimganj, in its meeting held on 17/7/2017, rejected the case of the petitioner on the ground of clause 1 of the OM dated 1/6/2006, i.e., not having the balance period of 3 years by the deceased government servant at the time of his death. Stop. Situated thus, the petitioner approached this court by filing a writ petition, WPC number 2322 of 2023, wherein this court, after hearing the parties, disposed of the same by setting aside the order of the DLC, rejecting the case of the petitioner. Stop. It is the specific case of the petitioner that the matter, it further appears that this court had also remanded the matter back to the respondent for a fresh consideration. Stop. It appears that thereafter, yes, where is that DLC?
Page 41.
Page
41.
Serial number 4.
After the DLC, by order dated 30/11/2023, recommended the case of the petitioner for consideration for appointment on compassionate ground and requested to obtain approval of the SLC. Stop. Today, when the matter is called, MSK so-and-so submits the instruction received from the Office of the District Elementary Education Officer by communication dated 16/6/2035, addressed wherein receives the communication dated so and so, addressed to the addressed by so and so to the District Commissioner Sribhumi, wherein it appears that the case of the petitioner for appointment on compassionate ground, which has been approved by the DLC Karimganj, is now forwarded to the Office of the Secretary to the Government of Assam Department of School Education Elementary for taking further action. Stop. MS so-and-so submits that since the matter shall now be placed before the state level in the next state level meeting, the grievance canvassed before this the relief sought before this court by the petitioner shall be addressed. In view of the aforesaid, MS so-and-so further submits, also submits that in view of the fact that the case of the petitioner shall now be placed before the state level committee's meeting in the next scheduled meeting, the case can be disposed of accordingly. Right? In view of the aforesaid endorsement made by the learned counsels appearing for the parties, vis-a-vis the communication dated 16 so-and-so, which is kept on record and marked as X, the instant writ petition is the instant writ petition in the interest of justice is disposed of by directing the respondents to consider the case of to place the case of the petitioner before the next SLC as and when the same is convened, and pass appropriate orders in accordance with law. In view, disposed of.
4 and 5.
Yeah, 4 and 5, huh? Ian Sharma.
Timing item number 16.
My lord.
Disposed of. Yes.
My lord, in this case, one additional affidavit filed by the present petition for a moment kindly may perish.
Who is appearing for the respondents?
Yeah, no. Counter.
I think PWD has
Assam and counter.
yes, yes. In Mr. Additional is a PNAT for PWD. He's paid for some time. Additional is a PNAT. He paid for PWD. He paid for some time. Also, as per the last order, also. So, also, I will be allowed to get hold of additional is Mr. PNAT.
So you want it to be passed off for the time being? It has already been called twice.
I will inform you also. All later, may come and fix that also.
At 2 p.m. my lord.
You inform him.
Apply.
Timing item number 24.
Yes. Where is the respondent counsel, sir? File to sir.
They have not filed affidavit, Lordship.
Back wages and retirement benefits.
Yes.
Where is CGC? What is happening with CGC? Because this is the second time I think this matter has been called, and in some other matter also there was no one from CGC.
Maybe next week.
Next week is all right, but where are CGC? The issues are important. Why there is no representation on behalf of central government? Heard Mr. A.K. Das, Learned Counsel, appearing for the writ petition. Huh?
MJ Gogol.
MJ Gogol, Learned Counsel, appearing for the writ petitioner. Are you also there, Mr. P. N. Sharma?
Yes, yes.
Also heard Mr. P. N. Sharma, Learned Counsel. Sorry, CKS Barwal, Learned Counsel, appearing for
4-7 and
respondent number 4 and
7.
7. None appears for the respondent CGC on call. Pertinent that this matter was called second time since there was no representation on behalf of the CGC when the matter was first called. Despite that, there has been no representation on behalf of CGC. It further appears that the claim of the writ petitioner in the instant writ petition is for payment of back wages and other retirement benefits pursuant to his reinstatement in service on the strength of the order of this court. Relist on such and such date next week or did it is needless to be clarified that in the event there is no representation on behalf of the CGC on that date as well, this matter shall be proceeded in accordance with law.
On 22.
The matter, huh?
Then pick item number 25 to 29.
Yes.
Contrary order, your lordship, for similar. Lordship, direct, similar, your lordship. Lordship, however, we have received an instruction today. May I place the instructions, your lordship?
Yes, give.
The instruction I've given.
Matter has been scheduled to be placed in the next. So it is already under process. So same direction and I can quote this.
Yeah.
20th September. So I think 4 months would be too much. Because this appears it will be done in the ongoing month, right? Anyway, heard MS. So and so Learned Counsel appearing for the petitioner. Also heard MSD Mushahari, Learned Standing Counsel, Elementary Education. Secondary Education. You all are teaching non-teaching staff of which school?
Item number 25, he's in Pandua High School.
Okay, 1 second. By way of this instant writ petition under Article 226 of the Constitution of India, the petitioners. How many petitioners?
There are lots of 5 petitions.
The petitioners are seeking provincialization of the services of the petitioners as assistant teachers within brackets arts at Pandua High School under Assam Education within bracket provincialization of services of teachers and reorganization of educational institution Act 2017 with effect from 1/1/2013 against the allotted post created by government letter number page 20 along with other assistant teachers of the petitioner school who were provincialized by the respondent number 2 by order dated 28/2013. Stop. Today, when the matter was called, MS D. Mushahari, Learned Standing Counsel, by placing the instruction dated 15/9/2025, received from the Secretary to the Government of Assam, Department of School Education, Dispur, Guwahati 6, to the received, sir, wherein it has been stated that the cases of the petitioners shall be placed in the next joint sitting of Department of School Education and Finance Department for deliberation on provincialization proposals, and that the same is scheduled on 20/29/2025. Stop. MS so-and-so submits that the coordinate bench of this court in WPC 2387/2025 has disposed of the writ petition filed by similarly situated petitioners by directing the respondent authorities to provincialize the services of the petitioners therein within the period of 4 months from today, in view of the approval given by the state level scrutiny committee. Stop. She accordingly submits that the that similar direction be also given in the instant case. MSD Mushahari does not object to the same. In view of the consensus arrived between the learned parties and considering that the case of the petitioners are already been examined in compliance of earlier order passed by this court, and now the matter is scheduled to be placed in the next joint sitting of Department of School Education and Finance Department, this court deems appropriate in the interest of justice to dispose of the instant writ petition similar in terms of the direction given by this court in WPC 2387/2025. Stop. It is accordingly provided that the respondent authorities the respondent authorities are accordingly directed to provincialize the services of the petitioner within the period of
2 months after verification, 2 months.
2 months from today after completion of the verification I think that's all. Nothing else is to be read in accordance with law. Disposal.
Also, in respect of the other petition, only school name is different also. School name is different.
School name is different, otherwise similar.
Yes. Yes.
So just provide the school names. Just give it in a piece of writing and against the item numbers.
Full name and post creation number.
Yes. Just give that details. I look. And all disposed of, and Ms. Counsel, since there are more than one petition, so please have a look at the draft order once this is done, so that there are no errors as terms of the individual informations are concerned. Yes.
Number 59.
May I please go out? Are my lord able to hear me?
Yes.
Yes.
Before my learned friend starts, Lordship was pleased to direct us to give the note on the dais. I am giving a detail. So that is the only part we have to do, Lordship.
Are you placing the note? Can I have a copy? Oh, yes.
Yes, who's appearing for the petitioner?
Sir,
For the petitioner.
online.
Yes, Mr. Kalla, yes.
Sorry for appearing virtually, my lord. I try and assist in this form, my lord. My lord, I prepared a short note for today's hearing, my lord.
Yes.
This
is just a reply.
Mr. Saika, no problem. If anything is required, Only, Mr. Chiste, I might, you may just have to show me that because I remember Mr. Saikia the other day had drawn the attention of this court to the initial order from where this relaxation comes. So that you will have to give me that once because I was reading the file yesterday. I couldn't locate that particular page. Too much of pages are there.
No.
So
This is started in 2015
something from the petition, if I'm not wrong, you had shown.
from the judgment.
From no, there was one annexure, perhaps.
I will show that. I'll show that.
That particular document. It's all right. He will give it. I'm just indicating so that he has it. Yes. Yes, Mr. Kalra, this is your additional notes rejoinder. Okay.
The note based on the submissions that were made by the state on the last date of hearing. If my lord would just have that this note is into 3 parts. I'm just giving a background, then I'll take my lord through each and every argument that I wish to advance today. The first part is the argument that have been taken by the state for the very first time in the counter submissions on the last day, which are not a part of the counter affidavit. So the first heading at page 1 refers to those 7-8 submissions that have been made for the very first time. And my lord had pointed out to me the other day that fresh arguments may not be accepted. Of course, I put in some judgments to show that yes, fresh grounds oblique defenses cannot be taken. Still, I will try and make an attempt to answer those. Then, my lord, at page 2 bottom.
Page
2 bottom is the judgments on each proposition of law that my lord will have to consider. Page 2 bottom. On each of the propositions that I could think from all these days. For each proposition, there is a judgment along with those relevant paragraphs that I have mentioned.
The first judgment is this state of UP.
Indeed, my lord.
So that is on what point?
If my lord would just have the italic above state of UP, which says representation to state authority.
Sorry?
Just the italic above.
Just 1 second, Mr. Color. Are you familiar with this?
Yes, my lord.
I think you can just take me through this note because I'm finding difficulty in understanding Mr. Kalra. Mr. Kalra, just here, I'm requesting the Mr. Day to just take me through this note that you have filed because your voice is not very legible. If some more clarification is required, we'll come to you.
Can I just make a request, my lord?
Sorry?
Can I just make one request?
Yes.
Would my lord consider requesting the court master to increase the system volume? Or if the system volume can be increased, my lord, my voice will be clear.
Volume is there, but I think there is some. Can you hear clearly? I'm not being able to hear very clearly. Anyway, this part, Mr. Day, na? Mr. Day can also do. Yes, Mr. Day, the first decision is on what point?
On the representation, my lord was asking on that day whether this 170 people had filed a representation before approaching this honorable court.
Okay.
My lord, the first note is on this, my lord. The second is on the same.
And that the paragraph is 10 and 11.
My lord,
so even without representation, it can come. That is on that.
My lord, that has been my land friend has shown that.
Have you given photocopies of these decisions?
My lord.
Yes, my lord, we have made a compilation.
Please provide photocopies of all the decisions, and in those photocopies that Mr. Day you provide, you just highlight that paragraph. Huh?
My lord.
Yes, next is Whirlpool. Yes, Whirlpool is that alternative remedy, or on what point Whirlpool?
My lord.
The next case, representation only. That is also on representation.
That is also on the representation, my lord.
Representation. Okay. So 2 cases on representation. Then number B.
B is also similar.
Representation. Okay.
C is 162.
Something to add in B. There's some. Am I better audible now?
Yes. I will. You say. Let me try.
Yes. In point B. Point B is regarding interpretation of a court order. My main ground in the writ petition is that because the Honorable Supreme Court's order is not being rightly interpreted, therefore a representation is not required. That is another ground.
Sorry, come again. On the apex court judgment is not
being rightfully interpreted.
All right.
So therefore B is on the fact that once wrongful interpretation of a court order is looked into, then a representation is not mandatory.
Okay, noted.
Then C. C is regarding Article 162. That merely an aid of Article 162 cannot be taken without there being a reference in the impugned notification or as a defense in the
This
counter.
is basically for changing of game of rule. Only on that 162 will not help. Correct?
162 is on the statutory backing, if my lord would
No, no,
recall.
I understand, but you mean to say that by doing that, you can't also change the game of rules.
No, there is slightly different. There is some slightly different argument there. I have challenged the competence of the impugned notification. The impugned notification, as per the state in the counter, can be on two grounds. One, there is a order backing, and one, there is a statutory backing. For the order backing, I have said that the Supreme Court order does not in any manner say. On the statutory backing, the learned AG last time argued that this is covered under 162. In answer to that, I have said that 162 will not apply because the impugned notification does not refer to 162.
Okay.
Or the minutes of meeting while passing this notification does not refer to 162.
Followed.
So therefore, it is on the statutory backing.
All right. Yes.
And then D. I say that introducing new documents amount to change of rule of the game.
Okay.
New documents cannot be brought in. They can
All
very
right.
well.
No, all right. Noted.
And then E. E is another separate argument where I say that the primary document has not been doubted till today. It is
This
no
is
one-
that for this you're relying Doli Chanda.
Yes, Doli Chanda, my lord. Unless the primary document is questioned, doubted, till such time the aid of secondary documents cannot be sought. There has to be first an averment or a doubt on the primary document.
Followed.
And then we see F. F is the after effect.
Consequences.
Yes, the consequence of an additional document cannot lead to me being rejected from the recruitment process. The consequences of 6 additional documents that are being sought, if I have 5 out of them, 4 out of them, the consequence cannot be to reject me or remove me from the recruitment process. At best, it could be to ask the school for some additional documents. The effect of non-providing a document, because my lord,
But that stage, Mr. Kalla, has not arrived. We are now we are considering a hypothetical situation that you will not have these documents, and suppose you don't have these documents, the state cannot simply not consider your case. This is what you are trying to say.
The answer is this, my lord. At the time of filing the writ petition, the state that had not arisen, but now it has arisen because in the merit list which has come in, most of us are not there.
No, that's because, okay, so you are saying that even if you do not produce these documents, they cannot withhold your case.
Indeed.
They have to consider your case.
Indeed, it cannot be a mandatory. They cannot be mandatory in nature. They can at best be guiding in nature. They can at best be explanatory in nature. They can't be mandatory in nature. Plus, can all of them be mandatory in nature? So this case, which I refer at para F, talks about the fact that yes, you want verification, ask for 1, ask for 2, ask for any of the above.
Okay.
And then G, my lord, there was another oral objection taken by the learned AG last time that multiple petitioners cannot challenge in a common writ. So G satisfies this, that if the cause of action for multiple petitioners is same, then it can be challenged. And then 3 onwards, my lord, are the concealments to which state has not replied to till date. So these are the 3 main headings of my today's argument. So if my lord would permit, can we start from 1 now? I will just take 1 minute on each ground.
But you have already, I have heard you in this. So basically now you are just supporting it with the judgments. Only thing I would have appreciated if these photocopies were here, then I could have just checked the paragraphs once.
Well, the photo,
But
by
you
the
don't
end of the
have it
day,
right now. Photocopy should have been kept ready.
it is being made.
Then it would have been easier for the court to appreciate in what context these have been held.
Yes.
But they are just being printed. By the end of the day, my lord will have it. When we'll flag it
That
also.
is after finishing your argument, then you see the whole exercise becomes very unnecessarily wasteful.
Can I then request one thing? I understand.
I would have appreciated it since you are relying in so many decisions. At least photocopies. This is the practice we follow in this court.
Can I request something then? I will
Yes.
start on with my arguments. Meanwhile, because this will spill over post lunch also, once the honorable court assembles post lunch, the copy would be ready.
No, then at 2 o'clock.
Very well.
Like
Very
this, not in this piecemeal manner.
Very well. Very well.
At 2 o'clock, you have the judgments ready.
Very well.
At 2 o'clock or at 2?
Very well, my lord. At 2 o'clock is good.
That no problem. Yes.
My apologies, my lord. We'll keep it ready.
That's all right. Mr. Day, there are libraries here. This is item number
60, my lord. My podium, how easy for us.
60.
Yes, my lord.
What is this, Mr. Sharma?
My lord, the petitioners, my lord, they're aged 5 and 9. They sought admission to respond number 4 school, my lord.
Respond number 4?
School, under right to education. Application fee was charged, my lord, amounting to rupees 17,000.
Rupees?
17,000 for both the students, my lord.
17,000.
70.
One
One second, my lord. This falls squarely against the provisions of section 12 of the RT Act. My senior friend, Mr. D. Sharma, for the school appears, my lord. He was here a while back. He just gone on a different court to attend the matter, my lord. He has agreed to allow the petition. The parents of the
We'll have it after some time.
at 2. Because he has agreed.
He's in court 24 right now.
So we'll have it at 2?
My lord.
At 2 or any time when, because then Mr. Sharma will be.
No, I'll be fine. I'll
So tell me at 2 or
At 2, my
when
lord.
he
At 2,
comes?
At 2, my lord.
They are supposed to bring information, as per the last. He meets all the qualification, but lots of name is not there. There is a.
Yes.
There is a meeting fixed, lordship, for all these grievances on 15, 16 and 18. So these petitioners have to visit. They have visited, they have given representation.
So what is to be done, Mr. Das?
Paragraph your lordship will fix the matter because they are to inform why her name was not there in the provisional list. So they are saying some meeting is there on 17, 18. 15, 16 and 18, lordship. So let it be on 19, but one post your lordship will direct them not to fill them.
No, I'm not doing that direction.
But 19, they will have to inform otherwise.
Well, let them, I'll fix it on 19.
Yes.
Because
Make the
no
whole
such
thing
orders was given at the time of notice.
Yes.
So anyway,
In terms
heard
of the
Mr.
advertisement, she
D.D.
fixed
Das,
all the-
Learned Senior Counsel, assisted by Mr.
Yes, sir.
J. Sahu, Learned Counsel for the petitioner. Also heard Mr. P. N. Sharma, Learned Standing Counsel, Secondary Elementary Education, and
About 5 minutes.
Mr.
I along that.
So and so, Learned Counsel appearing for
LCT respond number 5.
Standing Counsel NCT. Yeah? Mr. P. N. Sharma, no, Mr. P. N. Sharma, Learned Standing Counsel, in terms of the last court's order dated 5/9/2025, places the instruction received by letter dated 15/9/2025, wherein
Paragraph number 5, lordship.
a perusal of which it appears that the first provincial merit list, which has already been published on 10/9/2025 against the advertisement dated 26/12/2023, the petitioners, the candidates, to revisit, the candidates were asked again to visit the office of DEE for any genuine grievance with all supporting documents from 11 a.m. to 5 p.m. on 15th, 16th, and 18th September 2025. Stop. It appears Mr. B. Das, Learned Senior Counsel, submits that the
documents have been provided, man.
that the petitioner has submitted all the documents. Stop. Be that as it may, since the aforesaid letter is directing the petitioners to revisit the office of so and so as per the schedule, comma, let the revisit the office of so and so, comma, let the petitioner visit the office as per the schedule and place their grievances before the officer. Stop. Relist on 19 so and so, on which date up to date status of the matter be placed before this court by the standing counsel so and so. 19th is what day?
19 is Lordship.
Friday.
Friday.
19th is okay, or Monday?
Or Monday, Lordship.
Mr. Das, you are not because I don't think on 19 he will have this information.
On 23, Lordship.
Monday, 23rd.
They are going to make the appointment in the next month, I think, first week of thing.
So we are having it on 23rd, Mr. Das.
But I'm just,
First day you did not get that order, Mr. Das. Today it is for admission. Anyway, let that instruction come.
because he doesn't know why her name is not there.
All right.
23rd is Tuesday, Lordship, not Monday, Tuesday.
Orders. Number 33 and 34.
And in this case, my lord, non-compliance of the order dated 26/9/2019, my lord.
20 monitor.
33 and 34.
এইকেইটা কেছ কি হ'ল? এইটো এতিয়া অহা নাই নে? 33 and 34. Yes.
Non-compliance of the order dated 26/9/2019, my lord. And in fact, my lord, subsequently the respondents filed the appeal also. That appeal was dismissed. So now it's attained its finality. So since last 5 years, my lord, they have done nothing.
Yes, Mr. Khatonia.
Yes, my lord. Appeal was dismissed in the last month, my lord. So I'm praying for some time after vacation, my lord.
There was a stay.
No.
No.
Then
Appeal dismissed.
if there was no stay,
Stay was not.
pendency of appeal does not discharge you from complying the judicial orders passed by the High Court.
Yes, my lord. I'm not denying it, my lord.
No, I'm not on that. It's a 2020 matter.
Yes, I understand.
We are in 25. For 5 years, no affidavit seems to have been filed.
No, my lord. No affidavit has been filed.
Procause notices was received by the contemptness.
Yes, that is there.
They're not even bothering
No, my lord.
to file an affidavit before this court.
No, my lord.
Appeal may be filed, that is their right. They may file appeal, they may file review, that's another thing. But what about the present contempt proceeding? Why the contempt proceedings are being taken so casually?
No, look, I'm praying for some time so that necessary steps will be taken for compliance, my lord.
When?
After vacation, my lord.
Heard Mr.
R.
Islam, Learned Counsel for the petitioners. Also heard Mr. N.J. Khatonia, Learned Counsel for the respondents. Stop. It is submitted at the bar that the appeal filed against the judgment in order non-compliance of which is the subject matter in the present contempt proceeding has been dismissed.
Dismissed.
By?
But by the order dated
By
29/8/2025. My lord, in fact, appeal was not.
by the division bench.
By the
Yes, division.
By the division bench of this court. Full stop quoting, yeah. Mr. Khatonia seeks short accommodation. Submits that seeks a short accommodation by which date it is assured that the order of this court shall be complied. This is what you said.
For taking steps for compliance, my lord.
Mr. N.J. Khatonia assures that requisite steps for complying with the order of this court, if not yet taken, shall be taken by the next date of listing. in view of the aforesaid assurance, relist
Immediately after vacation, my lord.
on such and such date, it is needless to be clarified that the affidavits that the requisite affidavits be also filed by the next date of listing.
15 October.
Much obliged.
এটা বাজে নেই। You just give that name. Stop. Mr. So-and-so learned counsel for the petitioner submits that he has no objection if to that extent only the order is reviewed. In view of having heard the learned counsels appearing for the so-and-so, it appears that inadvertently there has an error has been crept into the order of this court dated so and so, which accordingly is corrected by providing the following paragraph instead of so and so. So following paragraph to quote unquote kori pele A7 to diba noy last to me against against nidi koba in accordance with clause 9.3.2 of chapter 9 of so and so. Okay, and that all etu didiba corrected accordingly. This order shall form a part of the judgment in order dated so and so.
Yes, look.
If it is because
That in accordance with law, yes. Yes, Mr. Chiste?
Yes, sir.
They're there, respondents are there?
Yes, sir.
Yes, sir. Take your seat, take your seat.
Item 62.
Yes. We have filed our affidavit lawsuit. We have. Copy to the.
Hmm?
Annexure B is the compliance order lawsuit. Annexure A is a letter from the secretary to the director.
Page 28.
Page 28.
Yes.
It's regarding approval of providing.
Just 1 second, let me just see the last order. The issue was, I think, what was the issue?
Execution of regular pay, my lord.
Huh?
Execution of regular pay, my lord.
Correct, regular pay. Regular scale pay, right?
Yes, my lord.
The order was to grant them that.
My lord.
After a verification, I think it was, right?
After verification, if they are found suitable lawsuit, along with the similarly situated person.
All right.
And those similarly situated person, they were given the same benefit, exactly the same notion.
Now page 8, at page 28, what are you saying?
Lawsuit 28 is the letter from the secretary lawsuit, giving approval for providing benefit of regular pay with the pay scale of the two numbers of fixed pay teachers in respect of the order.
For both the petitioners.
Yes.
So this is done.
Yes, this is done. And this is the order. And Annexure B, case petition is the order issued by the director.
This was when? 13-9.
13-9 lawsuit, secretary's letter regarding approval.
This is after the order of this court. And then page 29.
Is the order issued by the director of secondary education lawsuit.
Whereby it has been given.
Yes, on 14-9.
Yes, I think you have got it now.
My lord, can I point out only one thing, my lord? Subject to lordship's convenience. My lord, Annexure A, 28, page number 28, my lord.
No, what is it? Please tell me.
That is it. What has been written, it is from the Nawaz Chaudhary. There shall be no provision of payment of arrears. Same thing has been written in Annexure B, page 37, filed by the two contemnants. The payment.
What are you trying to say? Because it appears that that the order of this court is now stands complied.
My lord, we pray, my lord, that the similarly situated.
You see, this is not an executing court.
Yes. That they have to file an.
This is not an executing court. This is only a contempt court.
Absolutely.
The issue before this court was only the non-compliant.
Absolutely.
If they have any
cannot
grievance,
go any further.
Absolutely, my lord.
if they have any grievance, they can file.
Yes, Mr. Chiste,
Yes.
that is known to the court.
Yes.
But Mr. Chisde, why to create such a situation
Yes.
where these two orders could have been passed earlier and placed before this court? This has been only done because of the order that was passed on the last occasion.
Because lordship,
You see, why this delay?
to give some relief, we have to move.
Anyway, have you, is there any? The explanation is in para 5 and 6.
Yes.
The apologies, unconditional apologies, para 7, right?
Yes, Your Honor.
All right. Very well. Please take down. Heard, Mr.
Yes.
SSA Rahman,
My lord.
Learned Counsel for the petitioners. Also heard Mr. SMT Chiste, Learned Counsel, appearing for the contender numbers 2, 3, and 4. In terms of the last court's order, dated 8/9/2025, the respondent contender numbers 3 and 4. 3 and 4. Narayan Kumar Kuar, Secretary, Department of School Education, so and so, and Mamta, Director of Secondary Education, Assam, are also personally present. The issue involved in this contempt petition is the non-compliance of the order dated 19/7/2019 passed in WPC number 4808/2019. The operative portion of the order dated so and so reads as herein. Despite the clear, unambiguous direction to the respondent authorities to verify the claims of the petitioners after detailed representations are individually filed along with supporting documents, and thereafter, if found entitled, to pay the regular pay as given to other similarly situated teachers within a fixed time, despite receipt of the representations filed by the petitioners on 6/9/2019, along with all requisite documents, the respondent did not comply with the same. Since there was no affidavit in opposition filed in the matter, personal appearance of so and so and so and so was directed by this court on so and so. Today, when the matter is called, the aforesaid two respondents are present in person and has also filed an affidavit. Stop. Reading of the aforesaid affidavit, it appears. Okay. Reading of the aforesaid affidavit, it appears that the petitioners have been allowed the benefit of regular time scale of pay as per ROP rules of 2017. with effect from the date of their joining.
Yes, Lordship. We appointed when we.
Is this
Date of
just
joining?
keep, huh?
Yes, Lordship.
Should I say that or
Yeah, it was there in the order itself.
that's why
Yes.
with effect, huh?
Here, nominally with effect from the date of joining as so against their names.
Huh.
Yes.
From the date of joining as shown against their names. है ना? That being so, it is apparent that the order of that the judgment and order of this court dated so and so is complied. As regards however, it is apparent that there has been delay in complying with the order of this court. Reading the averments made in the affidavit to in support of their explanation for the delay, it appears that the explanations are sufficient and bona fide. That apart, it appears that in paragraph 7, an unconditional and an unqualified apology for the delay has been sought for. Having considered the above, this court is of the view that nothing survives for adjudication. There's nothing is of the view that since the judgment in order of this court has been complied and the delay has been sufficiently explained, nothing survives for adjudication, and accordingly the contempt petition stands. Yes, thank you for appearing before this court today. You are discharged. Discharged, huh?
Contempt closed, Lordship.
Closed.
Obliged.
Express our highest gratitude to your lordship for your lordship's interference. It is completed.
That's all right.
Highly obliged,
Yes.
my lord. Obliged.
What am I doing? Huh? What did you?
Item 37.
Then appears for the parties on call relist after 2 weeks on a date to be fixed by the registry.
Stamping item number 16.
Right, please, your moms.
Yes, what is this?
Promotion. Under rule 7.3 of
This has come for orders.
admission.
Admission.
Oh, it was time being.
Time being.
Because ADCLG asked me to appear in the matter on behalf of the government.
Okay.
I'll be appearing in the matter.
So then what is to be done?
It's the same. There's some this thing that they are not supposed to. The law does not support it basically. So if lordship willing to take up the matter today, I respond, or some other day.
We'll fix it for hearing then.
Lordship, we have already filed our affidavits and everything.
It appears, heard so and so Koridima. It appears that the pleadings are complete. The matter requires full-fledged hearing. Admit no formal notice. Relist for hearing in the month of November 2025 on a date to be fixed by the registry.
Awesome.
Item 39.
The contempt petition is filed, Lordship, for non-compliance with the order dated 28/7/2023. Lordship, the order starts at page 12.
Page?
12, Lordship. The operative portion of the order, your Lordship will find it page 14.
Page?
14 is the operative part, Lordship. That paragraph in view of the above.
Yes.
Accordingly, my lord, we have.
No, what is that you are giving? This is a contempt petition.
Yes,
Have
we
you
have-
complied?
Yes, my lord, we have released the provisional pension.
Yes.
Lordship, they have released only provisional pension, Lordship. That too, treating me as a forest ranger. They have said over the order of this honorable court, I have retired as an assistant conservator of forest road. I have retired on 31st of March 2023. Only the provisional pension has been released, Lordship. No, the GPF and other retirement benefits has not been released.
What to receive pension and other retirement benefits?
Yes, only the
Stands
provisional pension.
disposed of by providing that the petitioner's pensionary claim and retirement dues. Yes.
Because there is a vigilance case initiated against a petitioner.
Mr. Counsel, then where is your affidavit?
We'll file an affidavit.
When you just have to simply say something, why are you making it so complicated unnecessarily in contempt proceedings?
We'll file.
Do you want the contemptor to be personally be asked to be present in the court on the next date? When you said it is complied, it clearly says petitioner's pensionary claim and retirement dues. You want to file an affidavit? Ask for it. This court will accommodate you. But do not unnecessarily start passing on papers before this court in contempt proceedings. Heard Mr. H. Agarwal, Learned Counsel, appearing for the petitioner. Also heard Mr. I. Barthakur, Learned Counsel, appearing for which respondent?
Respondent 1 and 2, my lord.
Respondent number 1 and 2. And Mr.
4, my lord.
Mr. Talukdar, na? Respondent
4, my lord.
4. As prayed for by Mr. So-and-so. Yes, you are also filing? By so-and-so and so-and-so. Relist after 3 weeks, 2 weeks?
After 2 weeks.
2 weeks to enable the respondent contemners file their respective affidavit, show cause replies in the contempt proceedings.
They have, in the earlier occasions also, they have taken the same step.
It is needless to be clear. We will see what stand. Let it first come, Mr. Counsel. Have some patience. Your duty is to bring it to the notice of the court. The court has taken notice, and now let us see what they have to say. Yes.
40.
May I please, Your Lordship?
Yes.
Lordship, as per the order of this honorable court, the cause title, amended cause title has been filed, Your Lordship.
Filed. Amended because of impediment.
Because of, no, it was impeded, Your Lordship. The order, the address was incorrect, Your Lordship.
Oh.
So for the correction of the order.
So now what is to be done?
It was, have to be amended, a fresh copy have to be amended, Your Lordship. Because cause title has been already amended, Your Lordship. Notice have to be issued, Your Lordship. To the newly amended.
Heard MSG Bora, na? Learned Counsel for the petitioner. Also heard Mr. R.V. Goswami, Learned Standing Counsel for the respondent numbers 1 and 2, and MS
P. Sharma, Lord.
P. Sharma, Learned Counsel for respondent numbers 3, 4, and 5. Ms. Bora, Learned Counsel submits that she has submitted the amended cause title in terms of the court's order dated 26/5/2025 in terms of this court's order. A perusal of the amended cause title, it appears that the addresses of respondent number 6 and 7 has been corrected. Let notice in respect of respondent number 6 and 7 in their corrected address be taken by the petitioner within 3 days from today by registered post AD. Relist after 3 weeks on a date to be fixed by the registry.
Prayer, Your Lordship, one additional affidavit has also been filed, Your Lordship. That is maybe not in record, Your Lordship. For vacation any date, Your Lordship.
MS, so the additional affidavit is on record?
No, not on record, Your Lordship.
So that has to be also
been
MS so-and-so submits that an additional affidavit in the meantime, though has been filed in the matter. However, the same has not been brought on. However, the same is not available on record. Let registry verify and place the same on record. And when do you want?
Before pusa vacation any date, Your Lordship.
on the date to date. Yes.
On this one, before this has to go, on this matter, my lord, since notice has been issued, may come up after the vacation, my lord.
No, Your Lordship, because the issue.
Let
is-
us see if that
Not-
date,
not-
if required, we shall, Mr. Goswami. You are already there. So you have received notice earlier. Your affidavit by now should be on record. It is there, you filed. Very well then. Yes.
41.
May please, Your Lordship. 41 Lordship, first I have to apology because I have missed the item because Mr. My Lord Justice R. Majumdar's name was shown. I thought he is handling the case.
All right. When do you want it, Mr. Chester?
Lordship, can you give us some 2 weeks time at least?
You have to also file your affidavit.
I have to file affidavit and to instruction.
As prayed for by Mr. SMT Chester, Learned Counsel appearing for the respondent stroke contemptor, sole contemptor,
Yes, sir.
relist after 3 weeks on a date to be fixed by the registry to enable the contemptor file affidavit in opposition in the matter.
May pay for a fixed date, Lordship. May pay for a date.
It'll come, Mr. Counsel. Yes.
Obliged, Lord. 42 also, Lordship. Here, Mr. P. Kosik appeared on favor of number 2. Today, he is seriously
All right.
not able to.
How much time?
Here also, Lordship, weeks.
and 3 not appear.
One, I have asked Mr. Secretary to submit the Ukalama. 2, I have already informed in the hierarchy.
It's all right. These are coming after first time after returnable date.
Yes.
So heard MSB Devi, Learned Counsel appearing for the petitioner. Also heard Mr. SMT Chester, Learned Counsel appearing for respondent number
2, Lordship, on behalf of Mr. B. Kosik.
2, na?
Yes.
2
on
on
behalf of-
didn't see enter naam to pisot likhe on behalf of Mr. B. Kaushik for respondent stroke contemptor number 2. 2, right?
Yes, sir.
2. What about 1?
One, Lordship, I have
Mr. So further submits that he has also received instructions
1 and
to
3.
appear on behalf of respondent number
1.
respondent stroke contemptor number 1.
And 3, I have already informed. I will also receive Lordship. It will take some time.
Should I say 1
No,
and
no,
3?
Not receive. Not receive.
That way maybe recorded, my lord. 1 and 3.
Miss
It was listed
Counsel,
on 6/11.
can you
and
have
Mr.
some patience? It appears that AD card, it further appears that AD card has also been received back from respondent number 3. However, there is no representation on behalf of the said respondent. Mr. So-and-so Chester submits that he has also, I think it is not appropriate to write that because you have not got that instruction till now. Relist after
After vacation, Lordship.
3 weeks on a date to be fixed by the registry to enable these respondents stroke contemptors to file their respective return in the matter.
43.
Last time also there was no for the applicant no representation. Today also none appears for the applicant on call. Mr.
A. Rahman, appearing on behalf of Deputy Training Council.
Heard Mr. So-and-so. Give your name, huh? Anybody else? Anybody else? So this is for correction of the name. I think you don't have any objection to that.
No, Lord.
It appears that the instant interlocutory application has been filed seeking correction of the name of the father of the petitioner number 1 in WPC 1169/2011, wherein while disposing the said writ petition by judgment and order dated 10/9/2018, comma, the name of the petitioner number 1 was wherein the father's name, father's name of the petitioner number 1 was wrongly reflected in the cause list as Radha Ranjan Mitra instead of Rasha Ranjan Mitra. Stop. Mr. So-and-so learned counsel for the respondent says that he has received no objection, he has received no instruction to oppose to the prayer made in the instant interlocutory application. Having heard the learned counsel and having perused the averments made in support of the relief sought for in the interlocutory application, comma, it appears that the father's name in the judgment and order, in the cause title of the judgment and order dated 10/9/2018 has been wrongly shown as so-and-so instead of so-and-so. Father of so-and-so. That being so, the instant and is allowed by rectifying the father's name of the writ petitioner number 2 as Shri Rasha Ranjan Mitra instead of Shri Radha Ranjan Mitra in the records of WPC number 1169 of 2011 since disposed of on 10/9/2018. The cost title really good. Disposed of in the interest of justice, right?
44.
May I please? Lordship, as per law report 10/9/2025, a record of respondent number 5
awaiting
return, but without seal and signature. So Lordship could already direct
fresh steps
Lordship.
You have taken.
No, I'll take Lord.
Mr.
S.S. Raman.
S.S. Raman, learned counsel appearing for the petitioner, submits that in terms of the direction given by the Lawazima court, he is going to take fresh steps in respect of respondent number 5 within
2 days.
2 days from today. Relist after 2 weeks on a date to be fixed by the ministry.
45.
May please, Lordship. Lordship, kindly see last order, Lordship, 1/9/2025, Lordship, in effect, sir.
Yes.
There's order to produce review order, Lordship. And in this case, Lordship, my pair is that, Lordship, it order can't be reviewed, Lordship. Because
Yes.
We need 1 week order time.
Why? What happened to the review order?
Lordship, kindly see pair.
Counsel, one
Lord-
second.
Lordship.
Yes.
My lord, we want to file a review petition.
Who's stopping you? If you want to file it, you should have filed it by now. You've been taking time on the ground of some review. Have you preferred or not?
No, my lord.
Then?
We seek.
No, Mr. Counsel, is this some kind of a joke going on here in a contempt proceeding that you are seeking the permission of this contempt court to file a review?
No, my lord.
That is your right. You wish to file review, you want to file appeal, please go ahead. But what about the compliance of the judicial orders passed by this court?
No, my lord.
How can you be so casual about it? If you have some problem, file your affidavit. Has the contemptor not received show cause notice from this court? Received or not received? Show cause notice.
Received, my lord.
Then what does the show cause notice that notice says?
My lord.
What does the notice reads? Have you seen the notice? What does it says? To show cause as to why contempt proceeding should not be initiated against the contemptor.
Yes, my lord.
Where is the show cause? Where have you filed it?
My lord, previous that the respondent number 1 has sent for.
Order has been
review
partly
petition,
complied
for a review petition. So in earlier occasion also, we requested honorable court. But thing is that the conducting counsel is on leave, my lord, till 17. So that is why my lord to seek.
Lordship, my page, kindly see, have a look, page number 15, Lordship. Kindly look, page number 15, para
The
12.
counsel, please
Lordship.
bear with the court for a minute.
Lordship.
You are appearing for which respondent?
Or respondent 1.
2, you are appearing. You have filed your affidavit.
They have complied.
Heard Mr. D. Mohanta, learned counsel for the petitioner. Also heard Mr. P. Hajorika, learned counsel, appearing for respondent stroke contemptor number 1. And MS? P. Sohoria, learned counsel, appearing for the respondent stroke contemptor number 2. By way of this instant petition filed under Article 215 of the Constitution of India, as well as Section 12 of the Contempt of Courts Act 1971, read with Rule 9 of the Contempt of Court, within bracket Guwahati High Court Rules 1977, comma. The petitioner is drawing notice of this court again to the alleged willful and deliberate disobedience of the respondents towards the judgment and order of this court dated 22/1/2025, passed in WPC number 3058/2024 and WPC number 2776/2024. Stop. Yes, in which page is that operating part? This judgment, Mr. Mohanta?
Operating part is Lordship, page 16, paragraph number 16, page 16.
Operating portion of the said judgment and order reads as under para 16, huh? The reading of the aforesaid averment, a paragraph of the judgment dated so and so, it appears that the no, তুমি হেৰি কৰিবা 15 দি দিবা, huh?
And para 12, Lordship.
That the selection committee stroke state respondents were directed to make the selection and recommendation of the successful candidate solely on the basis of the marks secured by the candidates in the subject selection process. It appears that an affidavit in opposition has been affidavit has been filed on behalf of respondent contender number 2. However, in respect of respondent contender number 1, it appears that repeatedly time have been sought for placing up-to-date no. For obtaining necessary instructions stroke file affidavit in opposition in the matter. It further appears that you are for the BTC. That by order on 29/7/2025, the learned counsel appearing for the respondent stroke contender number 1 was directed to inform the court about the up-to-date status of the decision taken by the Secretary Education Department stroke BTC in order to comply with the directions passed by this court. It further appears that thereafter, when the matter came up before this court on 1/9/2025, the learned counsel appearing for the contender stroke respondent number 1 submitted that he is contemplating to prefer one review petition against the judgment in order dated 22/1/2025 passed by this court in so and so, and therefore sought listing of this matter after 2 weeks. Stop. Today, when the matter is called, Mr. So and so learned counsel for contender stroke respondent number 1 once again reiterates his submission that since they are contemplating to file a review petition, further time be granted to the contender. This court depreciates such casual attitude of the contemner, wherein instead of filing response upon receipt of the show cause notice of the contempt petition, repeated time on the pretext of filing a review petition is being sought, is being taken. Be that as it may, relist, give a date after 2 weeks, on such and such date, by which date, if the affidavit in opposition is not filed before this court, by which date, who is the contender number 1? So and so shall be personally present in this court. It is needless to be clarified that in the that the contender is also is at liberty to file affidavit if so advised. Did to deduct.
I was to show that Lordship, it was a consensus order, Lordship. Abide by the court.
46.
Lordship, in this matter, I am appearing for respondent number 1. Lordship, I need some time, Lordship.
As prayed for by Mr.
C. Sharma, Lordship.
C. Sharma, learned counsel appearing for the
Respondent number 1.
Respondent number
1.
Contender stroke respondent number 1. Relist after
3 weeks. Lordship.
3 weeks on a date to be fixed by the registry.
The 7th.
47 also I missed sometime after vacation law for on behalf of 1, 5 and 6 lawsuits. Though I have, oh, sorry, so I have not filed, I will file local, I have received, yet to receive.
Mr. SMT History Learned Counsel appearing on behalf of respondent, submits that he has received instructions to appear on behalf of respondent stroke contender number
1, 5 and 6.
1, 5 and 6 and accordingly shall be filing the power within
Within a week.
within a short period.
Yes.
He further submits that he shall the said
Affidavit.
why should I say that?
Yes, yes.
Huh?
Yes, yes.
You file it.
Yes, yes.
Relist after 3 weeks on a date to be fixed by the registry. In the mean, it is needless to be clarified that the respondent stroke contemnors shall file their respective returns by the next date of listing.
Oblige you.
Have you filed? Have you filed?
No.
So you file it if you want to.
48.
Please, Your Lordship, I filed this IA for implement of the School Education Department Authorities, Lordship.
I think it can be allowed. The only thing is that I think that I have disposed a couple of matters today and I am working with a limited strength of stenographers. I don't know if you'll get your orders. Otherwise, we will not be able to go back home today, looks like. Anyway, I'll allow it. Heard Mr. S. Day, Learned Counsel appearing for the applicant stroke. Stop. Also heard MS P. Sharma, Learned Counsel appearing for
Respondent number 2.
respondent number 2, APSC, and Mr. B. Chakrabarti, na? B. Chaudhary for respondent number 5, and Mr. S. Bhuiya, respondent number 1. By way of this application, the applicant is seeking implement of which respondents?
6 and 7, Lordship.
Deputy Secretary.
Yes.
Implement of the Deputy Secretary to the Government of Assam School Education Department, Kahilipara, Guwahati, and the Director of Elementary Education, Assam, Kahilipara, Guwahati, as proposed respondent number 6 and 7 in WPC number 4114 of stroke 2023. Yes, where is the reasons?
Lordship, page para 2.
It appears that during the course of hearing of the WPC number 4114 stroke 2023 and from the affidavit filed on behalf of the APSC, the presence of the aforesaid to respondent is necessitated. Correct? Paragraph 2 and 3 of the paragraph 2 and 3 of the said application reads as under, quote unquote. In view of the above, it appears that the presence of the respondents number 6 and 7 is essential and necessary for effective adjudication of the writ petition, accordingly allowed. Amended cost title disposed of.
49.
May I please, Your Lordship? As per office net dated 10/9/25, Lordship, service upon respondent number 9 and 10 is awaited.
Awaited?
Yes, ma'am.
Await
Respondent number 9 and 10.
both.
Yes.
Though office note dated so and so indicated that service in respect of respondent number
9 and 10.
9 and 10 was awaiting. However, on call MS as they Learned Counsel entered appearance on behalf of the aforesaid two respondents. You have filed your power.
Yes, Lordship, we have filed our vocal
Registry to she further submits that power in respect of the aforesaid two respondents have also been filed today. Let registry verify and place the said wakalatnamas on record. Relist. But what is supposed to be? Who is the other respondents? Yes, Mr. Chalya, you've been very quiet.
Lordship, here I'm appearing for the Finance and Treasury Office.
Ah.
There's some
corrections regarding the PPO is required, Lordship. Here.
No,
that-
affidavits are going to be filed from whom?
No, Lordship, here the PPO can basically.
That is the 8 and 9.
Yes, so.
Ship, PPO, the half of disbursers.
All right, as prayed for by the learned counsels appearing for the respondents, relist after 3 weeks to enable the respondents file respective return in the matter.
Mobilized.
Give your names, huh? You also give your names. Part somewhere number.
This is item number 6.3.
Lawsuit can be taken up on Monday next lawsuits, the review matter lawsuits.
Which one?
Item 63 supplementary.
Okay. As prayed for, Monday.
Oblige you.
Give his name, SMT Shiste.
Just 59.
Yes, Mr. Day? Mr. Kalra?
May I please, my lord?
Yes.
So judgments are ready. My lord would just have the note with me. I'll take my lord for the note and the judgment. My lord have that short note that we have given.
1 second. एक बार घुसाई दी तो नहीं ना ये जो फिर मिले
Paragraph number 10 and 9 sorry, 10 and 11
Yes, Mr. Kalra, you want me to take what?
My lord, could the note for today be taken up? Today's note that we had tendered in the morning.
Note. Mr. Mr. Chester, you will have to organize the court's file after the hearing gets concluded because so much loose papers are being given. It becomes very difficult to, trace it. So the documents which the petitioner side has given and the documents which the respondent side have given, maybe, you can just separate them and we can just put a blinders tape then. Otherwise, it's getting a little confusing. This is the note, I think, today's note.
Indeed, it says rejoinder submissions, hearing dated 15/9/25 on the top.
You all have not given any written arguments, no? But you had given a note today. Where is that note? This one?
Regarding Vidas.
This one?
Yeah, it's regarding Vidas lawsuit.
You dice.
Yeah.
Yes, Mr. Kalra.
Yes, my lord, may have the first new ground. So the first part, as I said, talks about the new stand, the new defenses that the state has taken up for the first time in their counter, in their submissions, not in the counter affidavit. So my lord would just have 1A at page 1.
Yes, you have already taken me.
Yes, no, I want to show from the relevant pages also because that will really add on more strength to my argument that which is the relevant page supporting this submission.
Yes.
Like for the first one, my lord would see diploma certificate of the petitioners has a date beyond 1/4/19. A lot of arguments were made on this context by the
You
learned.
want me to see what page?
Yes, please come to the writ petition, my lord. Kindly see the Supreme Court order, which is at page 568.
So this is that A, the details are that ABC. This is what you are reading now.
Yes, I am reading ABC.
So the first is the diploma certificate of the petitioner has a date beyond 1/4/19.
Indeed.
What do you want to say here?
I want to show two things. One is the Honorable Supreme Court's order at 568 of the writ petition.
Yes, to what effect?
To the effect that it does not cast a date by which the certificate should have been obtained. There is
That's
no.
all right. I am not on that. Yes,
Yes.
next.
The second document for point number A is the second last page of the same very note. Please see one RTI that was obtained with respect to the same aspect.
but petitioners have given wrong information in the forms regarding working status.
No, 1 second. My lord, I am trying to say that for point A, there is another second supporting document for point A itself,
Yes.
which is the second last page of this very note which my lords are having. Kindly have page 10 of the same very note.
Yes.
11 are the questions. Please see page 11. These are the questions put in an
Yes. No.
Yes, the questions my lord would see at page 10. Let us see the questions first. At page 10. Page 10 are the questions.
Yes.
The first question is 2017-19 NIOS
Page
dated
10
by...
of this note, Mr. Bakala.
Yes.
Page 10 doesn't have any, it has only one question.
Well, it has two. Descriptions of information sought, there are two. Is and does.
Is the requisitor below poverty line?
Well, below that, description of information sought. At page 10, what my lords were reading is requester below poverty line.
I think you are reading page 11.
No, my lord, what my lord was reading is requester below poverty line. Please go below that.
I think you are in page 11. Yes, come to page 11. Tell me. The last page, right?
No, first please see page 10.
Yes.
Below poverty line, there is some description mentioned. Just below that. The next very row.
Oh, is 2017-19 NIOS
DLED batch.
batches course is completed by 31st March 2019 or not?
Yes, that's the first question.
Yes.
Then the second question is very, very relevant. Does the certificate issued on 22nd May 19 imply that a course was completed by 31st March 19 or 22nd May 19, although our last exam regarding NIOS DLED was held on mid-March 19?
Okay.
Let us see
the RTI questions.
Yes, these are the RTI questions to NIOS. Please see the answers at page 11. The fourth row is public authority NIOS, which is the authority which conducted.
Has Mr. Saikia argued anything on this?
Yes, my lord, there were a lot many dates shown.
Permission was given that regarding that holding of qualification before 19/1/2019.
Yes.
Please see the answer. The answer to the first question is yes.
Yes.
That every course was completed on before 31st March 19. The second answer is very important. NIOS conducted DLED program for in-service untrained elementary teachers working in so-and-so as per directions of Ministry of Education and recognition by NCT. As per MOE and NCT guidelines, all the activities related to so-and-so have been completed by 31st March 19, including the final examinations.
Okay.
So this is the response to point number A. Let us please go back to the note now.
Yes.
Please see B now.
Yes.
Another aspect of fraud was claimed, saying that
Yes, wrong information.
Wrong information.
Yes, because you said, are you still working? That one document was shown where it says no.
Yes. For that, the entire advertisement needs to be seen that what was the real question put to me. Please have the advertisement at 574 of the writ petition.
Yes, you read.
Yeah, the relevant is 575. The question actually is, the regular teachers already working in lower primary schools under DESM are not allowed to apply in any post. That is the main point. So the advertisement says that if you are working in a lower primary school of the government run by the government of Assam, then you cannot apply.
So page
575.
All right.
So
Understood.
This no is an answer to that.
Okay.
Then please come, my lord, to the third point.
Yes, private school in the state are governed by the Assam non-government so-and-so. Yes.
Yes. The answer, there are a lot of, firstly, my lord, ground will have to be discarded because it does not form a part of the counter. This is not a stand taken in the counter anywhere. But, my lord, what is most important is those 6 documents, all 6 documents that a private school has to issue to a teacher working there is not mentioned, even in the act. Those 6 documents, I repeat, the school...
All right, noted. You don't have to repeat, noted. It is not mentioned there. Yes, next.
Then please come to 162, page 2. Page 2, article 162, ground D. This is another fresh ground taken by them.
Yes.
My lord would recall the impugned circular has nothing to say about 162.
Yes, you are citing those cases on this.
Yes,
Okay.
yes.
All right. Does not specify that those are under 162.
Yes.
Okay, fine.
Now, my lord, this is another fresh ground which now they are taking up in the past 8 years for the first time, that they did not do any verification under the directions of MHRD.
Okay, this is that showing that coordinator and all that. It is
Indeed,
only the names are given.
Indeed, my lord. This is
Yes. So
contrary
what do
to
you have to say to that?
There are two things. This is contrary to the records. It is contrary to the RTI given by them to us.
Where you are, that question was verification and said yes.
Indeed. Third most important part, it is contrary to the directions given by MHRD to the state. I will just once again show those directions.
Just show me, give me the pages. I remember those. Please give me the page numbers.
Yes, very well. The page number, firstly, for the direction given by MHRD is at 48 of the volume, second volume, CC. Convenience.
Second volume.
Yes, convenience compilation, page
Okay, then
48. Page 48.
Yes, then
Second thing is the RTI application, which is the second document in the last note. So there are two notes given by us, the first note and the second note.
that is not on record. It is only enclosed to your
With-
written note.
With the written note.
Yes, then
So these two things clearly show that the
that verification was done.
verification was done at by that time at that level. Then please come to ground F.
Yes, clubbing.
Clubbing, there is a direct judgment which I will just show now.
Yes.
Now the judgments I mentioned, Malord, all those judgment copies are ready.
Yes.
But meanwhile, can we just skip this? Let us come to the next part. Judgment we'll take up at the end. It will be easier.
All right. All right.
Please come, my lord, to page 3 bottom.
Yes. No response.
Yes, to these averments or the allegations raised by me, there has been no response
But
today.
that you have already said. You have taken me on the last occasion that they have not given parawise response to all that.
My lord,
Very well
yeah,
noted.
these averments may be important. One, as I said, is RTI.
Yes.
They have not responded.
Very well. Circular pertaining to UDICE and challenge verification. That's qua so and so.
Just,
Done.
just one
Okay.
thing I will take here, my lord. This UDICE point number B is very, very important. Kindly have, of the same very note which my lord is reading, these two circulars the government should have produced, but they have not done it. Please have page 7, page 8 and 9 of the same very note my lord is reading. Page 8 my lord may have.
Yes.
To show that UDICE is still not mandatory, please have the date on the top at page 8, 20th March 24.
Just 1 second. Mr. Chiste, that time I was trying to recall, I was supposed to ask you another thing.
Yes.
You know, one paper was given to show that UDICE is required. Something was given.
So that was a 2012 NCP.
Yes. What is this? What does this notification say, Mr. Chiste? Let me just get the clarification from them so that I can appreciate your response then.
Very well, my lord. Very well.
Because I was having a doubt here.
Very well, my lord.
If my clarification is concerned, I will note it down because let my Mr. Advocate General approach because it will be better for.
That is okay. I can give you that. But only thing I wanted to understand this, because from this letter, we can show that UDICE is now compulsory because of course you have shown that in some schools they are having it. That is all right.
Yes.
But the fact that UDICE is required,
Yes.
you see, because if it is required, then they have to have it. If it is not required, then it is not necessary that a school which is legitimately and validly running will apply for it because you have not made it compulsory, right? So in that situation, to ask a petitioner or reject a petitioner for non giving the UDICE record would be absolutely arbitrary.
Yes.
But suppose what I have been made to understand is that the reason for asking UDICE is to ensure that schools are validly run.
Yes.
You see, the purpose is something else, right?
Yes.
There is a lot of thing there for having UDICE code and all that. so that to ensure that this particular teacher who is applied is having the UDIS code means that he is not some fraud.
Exactly.
So these are the things.
Yes.
But which is the document which says that in the state of Assam,
Yes.
all schools must have UDIS code? This is one which you need to show. Huh? You, according to you, the 2012 document does not say, right,
Does
Mr.
not say.
Kala?
It does not say, my lord. In fact, there are two circulars of the government to the contrary.
Those are at page?
Page 8 of my present note, which my lord is reading.
Page 8.
Page 8. Please see, this is Board of Secondary Education, Assam. This they should have brought in to say that we have not made it mandatory in the state. But what is most important
All right, Mr. Chester, you take note of these additional documents.
This is secondary education. Secondary education lawsuit will not require any UDIS lawsuit.
Acha.
Board of
Mr.
secondary-
Kalra, the counter here that has been submitted, did you hear?
I heard, my lord, but answer is that
According to him, this is pertaining to the secondary education. And the case in hand is elementary, right?
lower.
Is elementary.
Please see page 9. Page 9 is the answer. Page 9 is for lower primary also.
Yes, serving from lower primary, upper primary, high school,
Everything.
higher secondary shall mandatorily have UDIS.
But the date of this is 2025. June 25, they are making it mandatory for the first time. And then also it is not mandatory. Please see the language. Wherefore it has come to the notice of the Department of
Anyway,
Social.
this is one aspect government has to clarify. You've understood why I'm asking. You see, because
Yes, yes.
I can understand the other conditions, but UDIS, which if you don't make it compulsory, then you see some school may not have it.
Yes.
Now, just because they don't have it, you can't make the teachers serving there suffer, right?
Yes. Yes.
Yes.
This read with one other document that I had given was a flow chart of registration done in 2017. That when we registered in this NIOS portal,
Yes,
there
this
also-
let Mr. Chester take note of these three documents because they have been newly introduced, and let us see what they have to say, Mr. Kala, on
Very-
this point.
Very well.
Yes.
Then please come to C, ground C at page 4. I have reread the counter once again, my lord of the state, which is ground C at page 4.
Yes.
There is absolutely no allegation qua my experience certificate.
This if you argued, yes, I have understood. You are saying that they have never, firstly, they've never disputed, correct? They have never questioned
Indeed.
your experience certificate.
Till
Yes.
date. Till date.
Yes, in fact, Mr. Saikya has fairly submitted also that is not their case. They are not saying that your experience certificate is manufactured or fabricated or they are disputing. That is
Right.
not their case. Correct, Mr. Chester? You are not, that way you're not experiencing, but you want to verify to ensure
Yes, you are.
that what is there, because of the fact that an experience certificate can be, there are various ways and means that cannot be, which cannot also be ignored, ruled out
Yes.
in the context of the past few instances that has taken place here. Correct? I think that was the background.
One of the argument of Mr. Learned Advocate General was that they have mentioned that some schools were not in function post-COVID lawsuit, but they have obtained the experience certificate in the year
That
2025.
is anyway, that is because
So
of
certificate.
see that is different that they are saying in this petition.
Yes.
But the fact that you yourself is asking for these these certificates without saying that the experience certificates which these people have submitted is wrong. This is what Mr. Kalra is saying. He's saying that if you had doubted, if there was a doubt as regards the experience certificate, then to clarify that doubt, yes, you could have asked for additional documents. But when you're not having any doubt, or you do not doubt the veracity of that particular experience certificate given by that principal, you don't say that in Mr. A's case that school doesn't exist, or in Mr. B's case that principal there was no such person as a principal at any stage. These are not yours. This is what his argument.
Yes.
Correct, Mr. Kalra?
Indeed, my lord. And
Okay.
I derived this argument from page 48 of the convenience compilation, the second volume. Because
Yes.
page 48 of the convenience compilation says, which is a direction by the MHRD, that to prove in service, because this is a course by MHRD, to prove in service, experience certificate is sufficient. That's very, very important.
That I have taken I remember that 2017.
2017 directive.
I remember. Yes.
And then, my lord, we are coming back to the note. I am just ensuring that in the next 15 minutes we'll be done, my lord. Ground D we can just ignore, we can skip. I have given the specific grounds that we have taken, but they have not replied to in their counter.
Very well.
I have raised those specific grounds just for convenience at one place. And then please see E also. Despite me taking a ground in the writ that they have said that because they are misused in the entire country, even in the time of argument, they could not cite even a single instance of the misuse.
That's all right. You have said that, yes.
Yes. And then please see F. Now, this is really the fulcrum or the heart of the matter. Please see F.
Yes.
In the counter, my lord, I have stated that there was a verification. In the writ, I have stated there was a verification done. Now, state should have been fair and transparent, replying to my averment made in the writ that what was done in 2017. They are silent. They could have come and said that we do not do any verification in the counter. They have not done that. They could have come and said that we did the verification, but we did not find your names.
All right. Noted. Next.
And then please see G. As I said, my lord, the conditions qua petitioners has been the same since 2019 after completing the course. It has not changed. In the previous recruitments for similarly placed petitioners like me, never such documents were asked for. Those in-service candidates and me, petitioners, is exactly on the same footing. Today, the Honorable Supreme Court has re-recognized what was in existence in 2007.
Okay. Next.
And then, my lord, J, I will show from those two judgments, my lord, which I am relying upon, that there is a expectation of reasonableness and predictableness in state's function. The one of the judgment of the Supreme Court, which I will say, which supports my ground J, is that a candidate should reasonably predict what can come in. Why do I say so? Just give me 1 minute on this. In 2017, when I was enrolling for the Government of India course, had I known that these 8 documents would be required, maybe some of us wouldn't have enrolled. I would have gone for a regular course of 24 months. So the mind that I had in 2017 when one of these documents were asked, the reasonableness in my mind was that for admission, when they're asking for one thing, later on they can ask for one thing, no problem, unless expanded by a judicial order.
Mr. Kalra,
Lord.
when you applied
Lord.
in
2017,
you knew one thing,
Lord,
that you have to give the certificate of diploma of 24 months.
Indeed, my lord.
You knew this. However, because of a relaxation being given by the state,
Yes, my lord.
in case you are, the 18 months comes in. 18 months comes in, right?
Lord.
And there also now, because of that MHRD notification, right?
Lord.
That in-service thing comes from the MHRD.
Yes.
Because
Lord.
of that, now if suppose you are an in-service teacher
Lord.
at that relevant point of time,
Lord.
then you can. So these
Lord.
you know.
Lord.
This you know, right?
I know very well.
Correct. Now tell me one thing.
Lord.
Has any of these things been changed?
Yes, my lord.
What has been changed?
The
Because you
change-
see, Mr.
Lord.
Kalra, what the state is now doing is to ensure that you are in service. They're asking for certain documents. How can you say that because they want to ask that too in view of the clarification we given in the review, coupled with the fact that the MHRD also says as in service on such and such date,
Indeed.
asking for certain documents for verification. All right, they may have done verification, they may not trust that verification, they want to do re-verification. They are only asking for X, Y, A, B, C documents. I'm only asking, I'm on this right now. Whether those documents possible, not possible, we for the time being, let us just leave it aside, right?
Well, it's two
And
answers.
then what is unreasonable here? Because the candidate knew that it is only, but yes, of course, if suppose a candidate was not in service at the relevant point of time, and because the documents doesn't say that a verification will be taken whereby all these documents will be asked, he took a chance, he has a legitimate expectation ki no, since I just have to get a certificate from a principal and that is sufficient. Now then this court, this equity court will now not. You understand what I'm trying to say?
Yeah. Lord, there are two answers to it.
I am with you as far as the other things are concerned right now.
I get your point, Lord.
But this, when you are trying to make an argument that look, in 17, this is what, and now this is there, you see, there is no change.
Well, I'll explain what the change is. Just give
Yes,
me two.
yes, please.
Lord, please, I have not shown this page previously, but it is a part of the document. It will be relevant from myself to clarify this query of my Lord. Please have page 76 of the second volume, CC. Please have page 76 of the convenience compilation. My Lord, this entire argument of the state that there is some relaxation is incorrect. I will establish that why that it is not a relaxation. It is the question of equivalence. They are two separate concepts. Please have page 76 for a minute, my Lord.
Yes, I have it.
This is an advertisement issued by NIOS, National Institute of Open Schooling, my Lord. My Lord, that on the top.
Yes.
Then my Lord would see on the left below the concerned politician's photograph, my Lord, this course. This is for my course, the present course, my Lord. This course is approved by NCT and MHRD. Anyone with this qualification can apply for job anywhere in India. Please mark this. This is prior to me taking the course.
Yes.
Then please see, my Lord, the second part of this, the pointers that are there, my Lord. Let us see, in fact, the first one also. Government of India has given an opportunity to all untrained elementary school teachers teaching in government aided and private schools to classes so and so to get DLED by 31st March 2019. Second is very, very important. Course duration is only 2 years. Please mark this. No further extension will be given. Therefore, rush to get yourself enrolled immediately. On request of the teachers who could not apply earlier, the date has been extended and last date for enrolling is so
Mr.
and so.
Kalra, I have not understood what is this. This is on the request of many untrained in-service teachers who could not apply earlier. Final extension is being given for registration for diploma.
So this is the advertisement by which this present course was conducted. This is from the newspaper. This is the Government of India's advertisement prior to the course starting. The course that we are concerned about, because it was a one-time course. This one-time course was conducted subsequent to this advertisement. This advertisement.
But on top it is said, no, you have started from the sentence which starts below the photograph, but next to the photograph there is one caption. Read the caption.
Last date of registration.
No, it says on the request of many.
Yes.
Read that.
Teachers who could not apply earlier, final extension is being given for registration of diploma in elementary education.
So that is what I think. This is some extension given.
But this is extension for the very same course. If my Lord would see on the
Okay, but this is not now. This doesn't say about the that relaxation is regarding the 18 months we were talking.
Therefore, what I am coming to, my Lord, the relaxation is a concept which the state government in its reply is trying to canvass. What I am trying to establish is this. Kindly bear with me for 60 seconds. At the time of taking this course,
then you give the diploma, the 24 months.
Well, we have given
relaxation. You see, in other words, it would be a relaxation. Otherwise, where is that advertisement? Which page?
Yes, it says equivalent also, my Lord. Please see the
advertisement.
Yes, very pertinent to us. Please see 574. 574, eligibility at 575 of the writ petition. It says equivalent.
574,
the advertisement starts. And the relevant at 575.
2-year diploma in elementary education by whatever name known.
Yes, this needs to be.
I don't see any equivalent written there.
Yes, I am just showing that. Please see.
No, but it should have been written here. Where are you reading equivalent from?
Equivalent come from, my lord, the Honorable Supreme Court judgment.
Coming from is different, Mr. Counsel. The advertisement, the essential qualification and experiences at page 575 is absolutely loud and clear. 2-year diploma in elementary education by whatever name known.
Yes.
This is what you either have this or now immediately let us go to that document which says this 18 months. Which is that document? Page?
Can I just show 620?
Then let's see that first. Page 18 months. Let me be very clear on this.
Yeah, let us see the recognition order.
Page 18. No, sorry. Which page is that? That 18
Fine. At
53 of the second volume book.
53.
Is 11.2.
What is most important is 54, my lord. Please see 54.
Yes, even Mr. Chiste also said 54 first, but before going to 54, let Mr. Kalra, would you mind placing this entire document once again?
Very well, my lord.
Just read it again.
Yeah, 53. It is a letter by MHRD to the NCT, dated 21st August 17.
That I can see, Mr. Kalra. Just read the letter. This is regarding. From there.
Training of untrained in-service elementary teachers in government aided unaided private schools. An amendment to the section 23 of the RT Act to extend the period of such training to 31st March 2019 has been passed by the Parliament. In this regard, it has been decided that NIOS will be the singular organization responsible for conducting the online DLED program through Swayam portal for all in-service untrained teachers. The tentative number of in-service untrained teachers at elementary level is 11 lakhs. That includes teachers working in government aided and private unaided schools. However, the actual number may change. NIOS will be completing all academic activities related to the above training by 31st March 2019. To ensure the above training through NIOS, NCT is directed to provide following relaxations under Section 29 of the NCT Act. Number 1, teachers who do not fulfill the minimum eligibility requirement for taking admission in DLED program, that is so-and-so, in class 12, will have to join NIOS and reappear for the class 12 exam to achieve the minimum qualification. NCT shall allow such teachers to take provisional admission in DLED program of NIOS, subject to them acquiring 50% marks in class 12 before completing the DLED program of NIOS. This would facilitate such teachers to pursue both the courses concurrently. Then please see 2, my lord. The DLED course will be from 3rd October 17 to 31st March 19. The duration of the course will be for 18 months. As the DLED program is of 2-year duration, NCT shall allow subsuming of 6 months internship period within the duration of the proposed online course through the Swayam portal, as well as all the teachers are in service and are already teaching. That DLED programs of 2-year duration is important. They are recognizing that fact. It is simply running parallel to the 18 months, saying that because they are already teaching, 6 months will be merged into 18 months. That's what they say. May I read once again?
Yes.
The DLED course will be from 3rd October 17 to 31st March 19. The duration of the course will be for 18 months. As the DLED program is of 2-year duration, NCT shall allow subsuming of 6 months internship period within the duration of proposed online course through the Swayam portal, as all the teachers are in service and are already teaching.
Yes.
And then 3 and 4 may not be important for today.
Yes.
The point that I'm trying to make, if I can just put it in my words, my lord, the basis of the state arguing that I have got a relaxation by this, their own document of MHRD may not really be right for this reason, that a 24-month is not being reduced. 24 months has 18 months of teaching and 6 months of internship. Therefore, it becomes 24 months. The ratio that has been applied here is that instead of doing 18 plus 6, you do 18 within 6. Purpose is 2 things. 1, there is a timeline. 31st March 19 has to be completed as per the Act. The second most important thing is that a regular DLED course cannot be done online. Here it is an online course. A person who is already teaching does not need to get a job again to do that internship. So that purpose of the internship is teaching experience. So a person who is doing regular DLED course will have to go and take a teaching experience.
So exceptional was made. An exception was made.
And therefore, my lord, this read with one line of the Honorable Supreme Court judgment is important because that really is the crux of the entire matter, that we are not claiming any relaxation. Please see, my lord, in the same very volume, in the writ, my lord, would just see one page with me. I'm sorry, I'm taking through another page. Please see 620. Please see 620 of the writ petition with me.
620.
620. This is the Honorable Supreme Court's judgment.
Yes.
My lord would have the second line from top. As such, any teacher. At 620.
Yes.
As such, any teacher who was in service as on 10th August 17 and who acquired the qualification of DLED by way of 18 months program through NIOS prior to so and so is a valid diploma holder and at par with any other teacher who has completed the 2-year DLED program. So therefore, what is being laid down, my lord, in my humble submission is equivalence. If it is the question of equivalence, my lord, what is not being sought from people who are equally treated as me? How can it be sought from me is really my argument. I understand if I was claiming some benefit.
Yes.
This is what's a benefit in my humble submission that I am trying to claim. My basic grounds in the writ is 14, Article 14. That a person who has done a regular course, a 24-month course, none of these documents are sought. I do a course as per Government of India's advertisement. Government of India says that yes, boss, if you want to do the course, you please give me one document, which is the principal's in service certificate. I give it. Today also I am ready to give it. Now the change from 2017 till 16th June 25. No document, no court order, or no communication says that apart from what was asked from 2007, more than 17, we will ask now. Till 16 June 25, no one asked. 17 June, which is the include circular, where for the first time, after 8 years, I am asked for. So this is really the change in game.
All right.
And
Mr. Kalra, just please point out another thing. Which page do I find the main judgment from which that review culminated?
Well, the main judgment, unfortunately, is not on record. We will produce it, Lord.
Please, Mr. Dave, please kindly give me
Yeah,
a copy
Jaydeep Singh
of
will produce it.
that. Because you see, what happened is that after hearing, and when we go back, we start processing it. So at that time, I was trying to figure out these papers and I'm not getting them. So, because that judgment, also this court would like to have a look. So you just give a copy, please.
In all fairness, I must also state, my lord, that when my lord are reading, my lord, it would be easier to read from the clarification orders for this reasons that whatever was said in the main judgment because of the clarification order. I mean, just as
please now don't.
No. Well, it will just be very confusing. It'll be very confusing. That is the point that I'm trying to make.
Dictate this court as how this court
absolutely
is going to apply this court's mind.
No,
I shall read whatever I think is deemed necessary to do proper justice in this case.
No, that is not the intent. The
Anyway.
point, yes. That is
no
not
offense taken, Mr. Kalra. On the lighter note, I said it. Yes.
Then, so I was coming back to the grounds, my lord. We were on the note that I was taking up the ground and how things have changed. That ground, my lord, would just have my note, the final note that we had given. So I was on the fact.
The note.
The note, the today's note, my lord.
Yes.
So when I say that justification of selecting, so why was insert? I'm sorry. We were at page 5, my lord.
Yes.
Page 5 of my note. At ground J. J was the one that we were last reading, my lord. that what is the basis of the justification of selecting these 6 plus 3 9 documents? Specifically, when I have argued that these 6 plus 3, most of these documents are not mandated by law.
Yes. That you have
Yes.
very elaborately taken this court on the last occasion. Noted. Point noted. Yes.
And then the last part is those judgments, my lord. Can I just take my lord through those judgments?
Yes.
And then we'll be done, my lord. Kindly, my lord, have the
Yes,
first.
yes, Mr. Dave, you be there. He'll come to you.
My lord would have the first judgment, which
Yeah.
my lord is regarding the representation of state authority, that state of UP and Whirlpool. Can I just show the relevant paragraphs directly?
Which one are you showing first?
First is state of UP.
Versus Muhammad Nu.
Mohammed Nu.
Para 1011. Representation, na?
Representation. I'm going a step ahead to say that even if there was a statutory remedy provided under the Act, which in the present case is not, still, may I read para 10?
Yes, yes.
Para 10 of this judgment says, in the next place, it must be borne in mind that there is no rule with regard to certiorari as there is with mandamus. So this is the present, it is a certiorari, that it will lie only if there is no other equal effective remedy. It is well established that that provided the requisite grounds exist, certiorari will lie although a right of appeal has been conferred by the statute. The fact that the aggrieved party has another and adequate remedy may be taken into consideration by the Superior Court in arriving at a conclusion as to whether it should.
Mr. Galra, this you are trying to say, the fact that I think this court had put a query that whether you filed any representation before approaching. On that you are saying these, that no representation is required.
Indeed.
Okay.
Only on that point. Whirlpool is also on the same line, Marad. I will not.
For representation, it's all right. I have noted. The other point, which one is that?
Then please see.
Till Whirlpool, I think it is also the next case is on representation. I think.
That also we can leave, Marad. Can I just show one thing in Whirlpool, Marad? Please see.
That's okay. That's all right, Mr. Kalra.
Very well.
This court may not go into that aspect.
Very well, Marad. I will directly.
As only on that point. However, you see, there is one issue which this court will certainly examine, because individually how one is affected, that has not been given. I don't know what consequence it will follow, but this is there in the mind of the court. So I'm only expressing to that effect. If you have anything in these three judgments, you can show.
Yes,
but not about representing and coming, because not filing representation, this court will not issue a certiorari. That is not required. I'm not going to go into that.
Very well, Lord. Directly on this point, what my Lord asked, kindly have the last judgment, which is
Nahesh Sridhar.
Annam Adinarana.
Which one?
Annam Adinarana.
Andhra Pradesh High Court judgment.
Huh?
Andhra Pradesh High Court judgment.
Andhra Pradesh.
Please have para 21.
Just 1 second. I'm not being able to locate that judgment.
Sorry.
They are all apex courts.
So the last judgment.
Last one is API Court, Lord.
My lord, the last one, which my lord is holding.
This,
yeah, the last one, my lord.
Oh, there is one more.
Yeah, at the back of the page, my lord.
Yes.
My lord, you can sample. Yeah.
Yes.
My Lord would have para 21.
Yes.
The legal position that now may be summarized, an application under 226 of the Constitution of India is a proceeding in a court of civil jurisdiction. The provisions of Order 1 and 2 can be invoked as far as they can be made applicable to the proceedings in a writ application under so and so. Ordinarily, two or more persons cannot join in a single petition to enforce the separate claims, but very, very important, where the right to relief arises from the same act or transaction, and there is a common question of law.
This is settled law.
So, my lord, the
Nobody is questioning about joinder of parties in that context. Now, the thing is that specific grievances have not been canvassed before the court. In that context, clubbing of cause of actions have been said. This is the argument.
The answer is this, my lord. Can I just make...
Otherwise, of course, if you have a common grievance, there is no bar in jointly coming. That is also different. But anyway, yes.
Can I just make an attempt to answer this? The specific or the common grievance of all the petitioners, 171 plus the new applicant that have come in, is rejection or possible rejection from
the apprehension that it will be rejected.
Apprehension from a recruitment on the basis of a notification, which is ultra vires the constitution and ultra vires the judgments.
All right. Very well.
That is the common submission in my humble.
Very well noted.
Then my lord would have. So we are done with the last one. Kindly have the representation also we may not look into again. Please see introducing new documents to prove eligibility. Kindly have, my lord, this is a very recent judgment, my lord, of the Honorable Supreme Court. It's called Tej Prakash Pathak.
See, there is no quarrel to that proposition that once the eligibility criteria is set and an advertisement is issued, selection has started, people have appeared, then you cannot change that criteria. I don't think there can be any quarrel.
Lord.
Now, here there is definitely no quarrel, but the situation is like, but you see, all these propositions have to ultimately be tested in the context of each case, right? So first and foremost, this court has to examine is that whether this impugned circular is introducing a new eligibility condition or it is merely asking for some more documents to just re-verify. You see, these are the two, because if the answer to the first question is yes, then no way, immediately it will be struck off because there cannot be a change of the game as you have you've been emphasizing since your first day of arguments. But I think that would be the issue.
Very well.
So now in Tej Prakash, what was the context? It here some which is that paragraph from where you can see what is the eligibility condition that has been changed.
Please
What
see
change?
para 20.4. If I can just rephrase my argument, my lord. The point.
Let us see this first, since you are placing a judgment of the apex court. Let us see the context.
Yes.
Because judgments of apex court are contextual.
Indeed, my lord.
Mr. Kalra?
Indeed, my lord.
Yes. 20?
Kindly have 20.4.
No, 24 point. Okay. No, that is not the facts. Where are the facts of this case?
The facts, my lord, would kindly see.
What is the fact? In what context this has been stated? Held. Sorry.
The facts, my lord, of the reference, because this is a constitution bench, can be seen at para 13.
Para?
13, 1-3. This is the...
One second.
Sorry.
You read paragraph 5 onwards.
Indeed, Lord. 4 can also be seen, in fact.
Yes, very well.
Yes.
From 4.
At the relevant time, the Rajasthan High Court Staff Service Rules so-and-so, framed by the Chief Justice of the High Court under Article 229(2) of the Constitution of India, governed the appointments. Under the 2002 rules, the Chief Justice of the High Court, by office order dated so-and-so inter alia, specified the qualifications as well as method of recruitment for the post of translator, ordinary scale in the following terms. We can just skip this, my lord. Kindly come to para
No,
6.
no, don't skip anything. Read.
Very well, very well. Translators.
You don't want to read what the court wants to.
No, my lord.
Huh?
I'm sorry, my lord, that is the
Yes,
impression.
read.
More than what is required. Translators ordinary scale. Recruitment to the post of translators ordinary scale shall be made on the recommendation of a committee nominated by the appointing authority on the criteria of selection from amongst the graduate upper division clerks or officials in equivalent or above grade but below the grade of translators ordinary scale with Hindi or English literature as one of the optional subject in graduation or lower divisional clerks with Hindi or English literature as subject in the post graduation and having minimum experience of 5 years.
Hindi and English. Okay.
Hindi and English.
Then
Competitive examination.
competitive examination. Okay, that part you can skip. Now come down to paragraph 6 later.
Later, while office order dated so and so, amendments were made in the office order dated so and so, thereby substituting the provision relating to the recruitment of translators ordinary scale by the following. Translators recruitment shall be made from the amongst the judicial assistants or junior judicial assistants having experience of 3 years by holding a test in English and Hindi translation. Candidates shall be given passages in English from judgments and records and shall be asked to translate them into Hindi. Similarly, passages in Hindi from the records or from some other books, etc., shall be
That
given.
is okay. The issue comes here. Minimum qualification you see shall be graduate, right?
Yes,
Preference shall be given to a law graduate. Now come to paragraph 7.
yes, minimum qualification shall be postgraduate in English literature.
So there I think is the change.
Is the change.
Subsequent amendment, right?
Indeed.
Instead of graduate, now they want postgraduate in English.
Indeed.
Then come para 8 on 19, examination was held. 21 so and so appeared, declared, and then so and so. Then para 9, some of the answers file writ petition. Questioning the decision of the High Court in fixing the cutoff date on the ground that it amounted to changing the rules. Where did the cutoff date come from?
Cutoff date, my lord, would be seen from the date
Oh,
of.
in here only. This was so because the Chief Justice of the High Court ordered that only those candidates who secured a minimum of 75% mark will be selected to fill up the post in question. As only 3 candidates could secure a minimum of 75%, the list of so and so. So it is in this context, yes.
Yes.
Because there was no minimum of 75 marks cut off earlier. So that means the entire eligibility conditions have been changed.
Please see 7 also, my lord, with me for a minute.
I've understood in this context, the ratio, you have to appreciate the context, correct?
Yes, I will make myself good, my lord. Just give me one more minute on
Yes,
this.
please.
Good. The point that I'm trying to make is this. I'll just show one more paragraph of this judgment. In 2017, the eligibility to get the course in question was one certificate, one document. If the other documents were not available with a person applying in 2017, he was out. He couldn't have applied.
No. From where do you say in 17 it is one document? Because the advertisement doesn't talk about document.
Yes. Please see that. Let us see that once again. Please come to the
advertisement doesn't say document. Does the advertisement say that experience certificate from the principal in support of the 18 months? Advertisement doesn't say that.
My basis is on the point where I had done the course today.
That's okay.
Today, because
that's okay. Mr. Kalra, we are only appreciating this particular point and not the others. As far as this point of yours, which you are arguing, is concerned, where in the advertisement it has been said that only this document, because you are saying by asking the additional documents, now you have changed the the eligibility condition.
So
this
the
is your argument.
Advertisement not of the recruitment.
Correct.
Advertisement of me taking the course.
That is different. You see, these are two, no, Mr. Kalra, these are two different situations. Now here the history as why this in-service was necessitated. This was necessitated because some documents were also placed on the other date where it has been observed that some teachers are not having the requisite diplomas. And in order to ensure that either you obtain these diplomas or Otherwise, a failure to obtain, you shall be removed. I think that document is also there.
None, my lord, I'm sorry.
You please give me the page numbers of all these documents which you had, Mr. Saikya on the last occasion has referred. Huh? These are the documents, because unless and until the history of why this 2017, the advertisement, it has to be correlated.
Yes.
Then only finally this court can apply its mind and understand in what context and decide. Otherwise, it becomes difficult, because simply by going by this, it will look like as if there has been some change in 17. This is not asked, but 17 is for a different purpose, as I am understanding. So
My lord, kindly have that document. I must clear this impression because this is really the heart of the matter. There is no such document. There is no such document on record till date which speaks to what the learned state tried to argue, if at all. Rather, the document speaks in my favor. At the cost of repetition, have that page 47 with me for a minute. It clearly says, and this is a directive issued by MHRD, the Government of India, to each state. The direction says, for teachers in private schools, a certificate from the principal would be taken to ensure that the teacher is serving in the school.
Yes, but this is in the context of that 2017 process in service to
Just one more thing, my lord. These certificates will be collected by the state. Very, very important. Why are we missing upon? Why is the government trying to miss upon this fact? One, this is not a request, this is a directive. Very, very important.
All right, noted.
Plus, my lord, it is the state coordinators which will enter the database. So I am trying to say today, because of the impugned circular, there is a change in the game qua this 2017 directive.
Noted.
And the judgment that, my lord, we were just reading, just see one paragraph in this context.
Yes.
Viewer, my lord, kindly come to page 24. Para 24.
Yes. Yes, read.
The principle of fairness in action requires that public authorities be held accountable for their representations. Please see the next line. Good administrations require public authorities to act in a predictable manner. Very, very important. And honor the promises made or practices established unless there is a good reason to not to do so.
Very well.
I'll pause here for 30 seconds, my lord. One, predictable manner in the present context would be that whatever was sought in 17, please ask again. Second part, if it does not have to be predictable, then what is the exception? The exception is there is good reason not to do so. Now, what is the reason here? Only one averment in the counter which says there are multiple cases where fraud is being committed. Let them show one real-time example. Not even after me pushing the last time till date, there is no one real-time example. So therefore, my lord, and please see para 26 also, the next in the same very judgment.
Yes.
Doctrine of legitimate expectation, my second ground. The doctrine of legitimate expectation does not impede or hinder the power of the public authorities to lay down a policy or withdraw it. The public authority has the discretion to exercise the full range of choices available within the executive power. The public authority often has to take into consideration diverse factors concerned so and so. The courts are generally cautious in interfering with the bona fide decision of a public authority which denies legitimate expectation. What really needs to be tested, my lord? Was there a legitimate expectation by the petitioners herein that when people similarly like me have been recruited without any of these documents? In 2021, they have been recruited by the state of Assam. 23, they have been recruited by the state of Assam. This course is done by NIOS. There is state-run course also by SCERT. Those are also for in-service teachers. There also they are recruiting similarly placed people like me in service without asking for these documents. So 3 instances of legitimate expectation that is built for me. I hope I am able to make myself clear.
Yes.
And then, my lord, similarly, there is another Honorable Supreme Court on similar ground, which is Sivananda.
Which one?
Sivananda, my lord. Kindly have the next judgment, Sivananda CT, on legitimate expectation. The first one was reasonableness. The other one is on legitimate expectation.
Which one?
Sivananda CT, my lord. This is by the Honorable Supreme Court, my lord. Sivananda CT versus High Court of Kerala. Para 17 of this.
1 second. This is Apex code, right?
Apex Court, my lord.
And what is the citation?
No, the citation is, if SEC, my lords are seeing, will be 2024 3 SEC 812.
2024.
2024, my lord. I could give the AR one also for my lord's convenience.
2024 SSC Online Supreme Court 3184.
Indeed, Sivananda CT versus High Court of Kerala.
My lord,
No, this is Rajasthan.
my lord, it's 2024 TSCC 799. Lord.
5 judge bench.
I am not getting it.
My lord, we can refer to my copy.
No, you just pull it out from here. These are the
My lord,
copies that you have given. Just pull it out from here. Maybe I have a blinder script depot multiple.
Just one more judgment and I'll be done, my lord.
Which is the other one so that he can pull it out also that.
The other one, my lord, is Dolly Chanda.
That I think I have seen. Dolly is there. Did you get the other one?
Yes, ma'am. Both of them.
If my lord would have the SEC copy, I could just read the gist to save time, or else I'll take my lord through each and every paragraph of this. This is a very important one.
One of those city question.
Would my lord have SEC copy?
Yes, yes.
Just see page 800 then, please. Page 800 of the SEC copy may be seen. The
page
800.
800.
Yes.
What is the paragraph number?
Well, this is the gist given in the beginning.
Now you're going to refer to the head note.
Well, I can read each and there are 10 paragraphs.
No, I don't want head notes, please.
Very well.
This
Let
code
us see.
doesn't look
Very
at
well,
the
very well.
notes.
Let us please see
Give me the paragraph.
Very well. Let us please see para 17 onwards then.
Yes.
The concept of legitimate expectation is mentioned a lot in para 17.
Yes.
Another important aspect that rises for our consideration in these batch of petitions is whether the High Court's decision frustrates the legitimate expectation of the petitioners. Article 233 of the Constitution provides that the appointment of persons to be posted as district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. Further, Article 235 vests with the High Court the control over district courts, including the posting and promotion of district judges. The maintenance of efficiency of judicial administration is entirely within the control and jurisdiction of the High Court. The governor, in consultation with the High Court, prescribes rules laying down the method of appointment and the necessary eligibility criteria for selection of suitable candidates for the post of district judges. According to 1961 rules, the High Court of Kerala was designated as the appointing authority and tasked with the responsibility of conducting the written examination and the viva voce. The actions of the High Court in pursuance of its public duty would give rise to the legitimate expectation that the process of selection of candidates will be fair and non-arbitrary. Then please see para 18. Doctrine of legitimate expectation under common law. The basis of doctrine of legitimate expectation in public law is founded on the principle of fairness and non-arbitrariness in the government dealings with individuals. It recognizes that a public authority promises or past conduct, this is very, very important, my lord, promise or past conduct will give rise to legitimate expectation. I will pause here for a minute. When I say past conduct, my lord, how has the state of Assam recruited similarly based individuals like me is important.
What is the context in which this has been done? What happened in the facts of this case?
The facts here, my lord, would kindly come. Please
No,
see.
you say it. You must have read the whole judgment. What is the facts of this
What has
case?
happened is that
Yes.
pursuant to the original notification coming out, the state of Kerala, my lord,
Yes.
prescribed the scheme for Kerala High Court Judicial Service Examination. The scheme was later amended, my lord. the original things that were required are mentioned at para 4. And then it was amended via subsequent notification at para 5.
Original is mentioned at para 4.
Indeed, my lord. One, two, three, four, five at para 4.
So these are not document.
No, my lord. It is here. This judgment is relevant for the doctrine of legitimate expectation.
Understood, but you said the original I thought I heard the word document.
Scheme. I'm sorry, my lord. I stand correct. I
Mr.
mentioned.
Counsels, please be careful when you say the words, because this court has been noticing sometime you say something but it is not there. I understand your intention is not that, but you see, the moment you said document, I went on a different.
No, my lord. I'm sorry. That is the. I mentioned scheme. What they wanted is at para 4. These are the 5 things that were required. And then at para 5, it was subsequently changed.
5 is changed.
Yes.
So what is this change now?
The change.
Provides for the mode of selection. 5 stipulates competitive examination. So the marks and everything has been changed.
It has been changed, my lord. It has been modified.
Okay. Yes, okay.
Then my lord would kindly come to para 28.
Yes.
That the past conduct of the concerned authority is very, very important. That how have they dealt with similarly placed individuals at a previous stage.
At 28.
28. The substantive legitimate expectation.
Yes.
May I read, Lord?
Yes, yes.
R versus North and East Devon Health Authority X so and so, the Court of Appeal laid down the test of abuse of power to determine whether a public authority can resile from a prima facie legitimate expectation. It was held that the frustration of a substantive legitimate expectation, very, very important, by public authorities would be unfair and amount to abuse of power. Importantly, it was held that the abuse of power constitutes a ground for the court to exercise judicial review of executive actions. I will pause there for a minute. As I said, my lord, this example I had cited in the beginning, that in 2017, when I was enrolling for this course, if any authority would have asked me for 10 documents, I had an option at that time that if I had those 10 documents, I will enroll for the course. If I don't have those 10 documents, I will go for the regular DLED. Why would I enroll for the course? I had that option at that time. The fact that none of those 10 documents were asked from me in 2017 when I was enrolling, there was a legitimate expectation, read with the advertisement which I showed, brought into me, which said that I can apply anywhere in the country. The advertisement of the government of India, my lord, in 2017 says, I can apply to anywhere in the country. It also says that my course would be treated as a 2-year course. The advertisement records that. So therefore, my lord, those are the 2 factors by which my legitimate expectation of being treated at par with a regular DLED course is built in 2017. It is built, it is exercised in the subsequent recruitments. As I said, this is the 3rd recruitment after my course being completed. The first recruitment was in 21, the other was in 22, 23. The present recruitment is the 3rd one. So in both those recruitments, nothing was asked for.
Okay.
And then, my lord, the Dolly, my lord, have seen.
Yes.
So therefore, my lord, my humble.
I hope you're giving the citations to the other side as well.
Yeah, my lord, the note has it. We've tendered the note, my lord, and the note has all those citations. In fact, the paragraphs are also mentioned in the note.
Very well.
So, my lord, with these, it is my request, my lord, to kindly consider and test, if possible, my lord, test it on both these aspects. That one, is there a power to ask for these documents? Second, can they be made mandatory in nature? One, My lord would also want me to consider Dolly, read Dolly for a minute, or would my lord seen it?
No, Mr. Counsel, you were asking me the test, so I was just writing it.
Oh, very well. So the test is, I will take my lord through Dolly also. That is
I'm just writing that.
Yes.
I'm not stopping you from placing judgments.
Grateful.
I'm only taking a note of your submission.
First is, my lord, whether the state has the power or the
Yes, I heard you. Let me write now.
Wait.
Now you've made me forget. The first you said power, and then the second is what? What is the second test?
Mandatoriness. Can they be mandatory in nature?
Yes. Now come. You want to show something from
Wanted to show Dolly, my lord.
Dolly Chanda?
Dolly Chanda.
Yes.
This is also, my lord.
Para 7.
7, my lord. 7 and 8.
Yes.
May I read 7?
Yes, yes.
The general rule is that while applying for any course or study, we're not about recruitment, or a post, a person must possess the eligibility qualification on the last date fixed for such purpose, either in the admission brochure or in the application form, as the case may be. I want to pause here for a minute, Lord. This goes beyond recruitment. It says that if you have to apply for a course, as on the last date of the application, which I just read was on October 17, you should possess the documents as mentioned in the brochure by that time. So as on October 17, which was the last date to apply for the present course, I should have had the document which was required in the...
All right.
And then let us please see further. As the case may be, unless there is an express provision to the contrary, there is no express provision to the contrary in the present case, there is no caveat in any of these documentation that later we can verify your in-service by asking you 10 more documents, none of that, that is no one's case. There can be no relaxation in this regard. That is in the matter of holding the requisite eligibility qualification by the date fixed. Now, what is the date fixed is the question that I put to myself. Last date of applying for the course in 2017. This has to be established by producing the necessary certificates, degrees or mark sheets. Similarly, in order to avail the benefit of reservation or weightage, etc., the necessary certificates have to be produced. These are documents in the nature of proof of holding of a particular qualification or percentage of marks secured or entitlement to benefit of reservation. Depending upon the facts of a case, there can be some relaxation in the matter of submission of proof, and it will not be proper to apply any rigid principle. That's very, very important. Rigid principle as it pertains in the domain of procedure. Right. 30 seconds, I'll pause here, my lord.
It's all right.
Ultimately, what we are today on, my lord, is a procedure that should have been done in 2017. I am not shying away to say that if 2017 these things were asked from me, I wouldn't have given it. Maybe things would have been different.
All right.
And then para 8 also, my lord. There's one more paragraph in this. I am reading the last line of 7. Every infraction of the rule relating to submission of proof need not necessarily result in rejection of a candidature. The last line of 7. Every infraction of a rule relating to submission of proof need not necessarily result in rejection of candidature. And then C8.
Yes, read.
Yes, the principle was explained in and applied in so and so. The controversy here related to admission to a postgraduate course in medicine. The relevant rule provided for addition of 10% marks if a candidate possesses diploma in the relevant subject of or subspecialty, and this benefit could be given only if the candidate's success in the diploma course was brought to the knowledge of the selection committee. The prospectus provided that the attested copies of the statements of marks and other documents should be extracted with every application. 3 such candidates were given admission who had not attached the certificate of having passed the diploma along with their applications. Their admission to postgraduate was set aside by the High Court on the ground that their applications wherein they have claimed the benefit of diploma were liable to be rejected as the requisite certificates had not been attached. This court, the Honorable Supreme Court says, this court, speaking through Justice Krishna Iyer, reversed the judgment of the High Court and held that the admission to the candidates had rightly been given as they had in fact passed the diploma before the date fixed. The relevant parts are produced here. So therefore, what they're trying to ultimately establish here is, or to speak in this judgment is, that even though the certificates so-called were not attached, but it was ultimately reversed by the Honorable Supreme Court, saying that whether they have done the course, whether they were in service in the present context, I'm trying to draw a line. And then finally at para 9, my lord, the appellant undoubtedly belonged to the reserved MI category. She comes from a very humble background. Her father was only a Naik in the armed forces. This is relevant to the facts of the case. They hold in favor of the proposition I'm trying to canvass. So therefore, my lord, in all these submissions, my lord, and I am grateful for the patient hearing all throughout, my lord. Deeply grateful, in fact. My lord, may kindly consider on two aspects, my lord, of course, on setting aside the improved notification. If not, my lord, then not having it as a mandatory nature. If possible, my lord, on those three aspects. As I said, the first part of the improved notification, the second and the third. The first part has, the most important part is a UDI score. The second, of course, is the diploma, etc., which all of us have. That's not really.
1 second. So, which are those three? One is UDIs.
But there were three parts. The first is to prove in service.
Yes.
Which six documents, my lord.
Yes.
Out of the six, one is UDIs,
Huh.
which is the most problematic, which is not even mandatory till today.
Yes.
Then one is the school management committee.
All right.
And the third is those pay slips, salary statements, basic DA, etc. These are the six documents.
Okay. Noted.
And meanwhile, my lord, in my humble submission, unfortunately, my lord, of course, the interim we were having the writ may be not rendered infructuous, my lord may consider till such time the judgment is pronounced, not some protection may be granted. So
Don't worry, if you're before an equitable court, this court will do, if I'm wrong, if this court finds that a wrong has been done to the petitioner, this court will set it right. Yes, Mr. Chiste, I need that clarification.
Regarding UDIs. From when it was made.
Yes, number one. And also for the school managing, because I remember it, this was shown, but does this say about under this act, is there any, I think there was having to, it was mandatory for the schools to have a school managing committee, correct? Which is that provision? No, you take a note of it. Ms. Chutia, just keep a note of all this. When would Mr. Taika give these clarifications?
For this week, I think he will not be possible. Monday next.
That is going to be too long. I would have. I don't want to keep it for, because you see, then I will forget. Everything is fresh. I just wanted the clarification on the UDIS.
Yes.
And under which provision, if you can give it also, it's only on that, because you see, you don't have a right to reply to a reply argument, right?
Yes.
But after hearing all the arguments, there are certain clarifications which the court is now asking from the state. Number one, whether UDIS has been made mandatory in the state of Assam. If yes, from which date? Number one. Number two, under the provisions of this act, where it has been laid down that these schools, government, government aided, unaided, private, should also have a school, mandatorily have a school managing committee.
Yes.
I think it is there.
It's there in the act itself.
I am sure. Mr. Gogoi, you know that section.
2006, yeah.
Huh?
On the basis of that particular provisions, one OMR also issued by the government.
Correct. Which is that provision? You want which book? This court will give you the book. You say which book you want. I want to see that provision.
In fact, if I can just be permitted, the impugned notification says minutes of school management committee to appoint me. So they will. Really
I understand. You see, for that, first of all, there has to be school managing committee.
Indeed.
Now, suppose that there is no provision for a school to have a managing committee. Where is the question of having the minutes?
Indeed, my lord.
Correct.
Indeed, my lord. I'm so grateful.
Excuse me for a minute.
Hmm?
21, my
21. This is 2009. Yes, right. This is the section which I had in my mind. Now, as per this, so therefore, Mr. Gogoi, this court wants some help from you. Please come forward. Uh, as per this provision, only all these schools, private schools, are now having
Yes,
the
yes.
school managing committee, correct? Except DPS,
All.
isn't it? Now, what is the meaning of a government aided school?
Government school also the fund was supplied provided by the government also.
So that is not purely a private school.
Lordship,
It may be
CI concept earlier occasion college also lordship government aided was there also. Government.
an unaided.
And it was
So that is private.
private lordship.
So why is it written private, government aided, and unaided? So there are specific meaning ascribed to these
Private
three.
Private is completely
Private.
private. And private law, that's why in respect of lordship, societies schools are private schools. Societies were treated as a private school lordship. And unaided school is a somehow government connection is there lordship.
All right.
Aided
All
school
right.
is lordship.
So, but there is no fund.
No fund.
No fund.
Aided school is lordship directly provided the fund by the government lordship.
Okay. And government aided is where the fund is. It is funded by the government.
Lordship.
Okay. All right.
Just one last thing before I end, my lord.
Yes, yes.
Just sorry, my lord. Just one last thing. My lord, in the advertisement, my lord had put this question to me, therefore I am answering, my lord. In
Yes.
the advertisement of the present recruitment, the advertisement relies upon another circular of 29/11/23. I will show that. There it is mentioned that we are eligible to participate. There is no bar on us. It specifically
Yeah,
says,
which page?
Lord, that circular is not on record, but I will show that. Kindly have page 575 for a minute. This is a government document, my lord. If my lord would permit, only then would we produce it. Otherwise, my lord, it refers to. Kindly have page 575. Of my writ, my lord.
Yes.
My lord would see point 15.
Yes.
It says eligibility criteria for lower primary schools as per government in Department of School Education notification number dated 29/11/23. Now this notification para 20, my lord. I will produce this notification. It is not on record, my lord. This is a government notification.
Where's Mr. Chistek on? Yes.
Can I just read para 20 of this notification?
Mr. Chistek, also have this notification place it before the court next time. The notification which is mentioned in your advertisement at page 575. That is 29/11/2023. It's there in that clause 15 that it is mentioned. Just I want to see the entire notification.
Para 20
So
of
when
the
can we have it?
Friday notice.
Friday? Sure.
Friday, so
All right.
I just
And please give a note.
Yes, I've
indicating those page numbers and all. All right. Yes. Good.
I'm so deeply grateful, my lord.
So, I'm as for you see, it is understood that arguments are all completed. It is only clarification from the state government on that UDICE and that initially from where that that 2 years thing, that particular page.
Relaxation.
Yes, relaxation, exception, and what was the other word? Equivalent. Whatever be it.
Yes, that's it.
All right. So Friday, huh?
Yes.
My lord, last time my lord had only requested the other side that they will not do anything till Friday. My lord, the same request, if possible, my lord, may be made. The writ petition may not be rendered infructuous because they are
All right.
courts, my lord.
We good?
Very well, my lord. Grateful, my lord. Deeply grateful.
One hearing matter is there, Lordship, after clarification, Lordship.
Okay.
Can we fix it, my lord?
All right. Give a date.
After
That last matter.
last matter.
Okay.
Grateful, my lord. Deeply grateful.
Yeah.
To Friday for him, there is
আমি রাত্রি দাম পাবো ঠিক আছে কপি দিব আহিছে টাকাৰিতে এইবিলাক দিব আহিছে এনেক্সাৰ বিলাক দিব আহিছে